Pass over item number 20.
Yeah, please, sir. Well, at last occasion, the ISS produced a report for the dishonorable courtman saying that she's stretching the gap. To my information is, my lord, she is residing at Hyderabad. She has telephoned to his mother, father, and his elder father-in-law, my lord, saying that my life is in danger, took me back. And when they are approaching the police officer are threatening the informant. Don't come to the police station time and again you have filed a case at High Court. High Court will take care of this issue.
Give a copy to the London State Council. This anticipatory bail application was finally disposed of or interim protection granted?
That information I don't have.
You should have. Are you aware that an anticipatory bail application has been filed by some of the co-accused persons and it is mentioned that no coercive action shall be taken?
I have not.
What is your information, Mr.
I have not checked it, my lord.
A BLAPL number.
In the last portion of this report, he has said that he has completed the informant as no information is given. The informant had been with the police have given two numbers, my lord, where the doctor has called to him.
7546.
Give me.
2023.
Give me the two numbers in writing. Right, got a cover the victim called the parents. Yes, my lord. And say that they will kill me immediately. Rescue.
Scroll down, scroll.
And she is there in the Hyderabad. The information is, my lord. She's telling.
Okay.
And was Goran Gopal, my lord, which his residence is decided.
Order 15 November 23 order টা
17 বছর সময় দিয়েছে 5 বছর
and share it so that they can also see this. Mr. Das, and please see, this is the order pass. Is it visible to you?
No.
Right.
आप टिके एनालाइज size.
Asila. Scroll down. This is the final order pass. Yes, scroll down. So, submission made that main allegation is against Raghunath Panda, who was in love with the victim. Petitioners are the parents, and the victim girl has not been rescued. Inclined to entertain this application, which is therefore rejected. Scroll down. So, where is that? How you have mentioned this?
You have not checked it. Initial what the not.
There is no.
Rather,
there is a copy of
the previous or application was
No, this was when you are filing the status
Myra,
report,
you
which
should
is
check.
dated 7/1/2024.
Myra.
This order was the anticipatory bail application was rejected in November. This is totally misleading to the court that no coercive action has been taken. Might have been granted earlier, but
they have not checked. And the police report is also otherwise. So a stand was taken for the government bench that he is in love with the victim.
Let the
report
victim
says
telephone to his father and
innocent
stated
girl
that
who
we
was
withdraw the case before the High Court, or else will kill you.
wait.
May I, my lord, let it pass over. I am asking the IC to virtual mode will appear so that.
All right, pass over. Pass over. Yes, next.
Item 22.
Please, Your Lordship. Last petition, IAC has submitted a report by law and sought for approving stamp to rescue the victim. As per my instructions, I not covered that.
You have got the copy of the status report?
Man.
So what is, you have given the name and you know, Parathi Devuri, ASI of Police, Kamakhya Police Station, Dhenkanal, is present. The status report dated 7/1/2024 has been filed by the Land Council for the state, which indicates various steps taken by the investigating agency for for rescue of the victim girl and for apprehension of the accused named in the first information report. The investigating officer seeks some further time to carry forward his investigation and to do the needful in tracing out the victims, also to arrest the accused. The status report is taken on record. Copy of the same has already been served on the Land and Council for the petitioner. Out of this matter, in the week commencing from 19th February, 19th February 2024, the personal appearance of so-and-so is dispensed with.
Item 23.
Partner girl of the petitioner has been missing my note. They have lodged FIR on 11/4/2023. My period. Police have not taken any action.
My lord, in this case, my lord, I'm submitting a status report. Apart from that, today they are moving to Raipur, Chhattisgarh.
Huh.
There's some information they got that now in Raipur. So they are today, overall they are moving.
Okay.
That's why I could not come.
All right. We are adjourning to another date.
My lord.
You serve a copy of this
All right,
status
sir.
report. The Land Council for the state has submitted the status report in connection with Muri Bahal PS case number 59 dated 11/4/2023 under section 363 of the Indian Penal Code of SI of Police Muri Bahal Police Station, which is taken on record. Copy of the same has been served on the Land and Council for the petitioner. Land Council for the state submits that in connection with the investigation of this case, the IO is supposed to go to a particular destination to trace out the victim and to arrest the accused as per the reliable information received, and the matter may be taken up on some other day. Code of this matter in the week commencing from 19th February 2024. Personal appearance is dispensed with.
Item 25.
Minor doctor of the petitioner is kidnapped since 9/9/2023 by the OP $5. The last person was directed to take instruction.
You have received a copy of the status report?
No.
Name. You are the investigating officer.
My lord.
You have not mentioned that at what places raid has been conducted.
Sir, raid has been conducted at Bolagad PS, Fatehgad PS bordering areas. ଆଉ ଯାହା ଯାହା ରିଲାଏବଲ୍ ଇନଫର୍ମେସନ୍ ଥିଲା ସେଥିରେ ସବୁ ରେଡ୍ ହେଇଛି। ସିଡିଆର ବି ସାର୍ ମଗା ହେଇଛି।
କାହା ଘର ମାନେ କାହା
ଆକ୍ୟୁଜ ର
ରିଲେଟିଭ୍ସ ଘର ନା
ଆକ୍ୟୁଜ ର ଘର
ଆକ୍ୟୁଜ ଘରଟା କୋଉଠି ଅଛି?
ବୋଲଗଡ଼ ଏରିଆ ସାର୍।
ହଁ ତା ଫତେଗଡ଼ କୋଉଠି କଣ ପାଇଁ ଯାଇଥିଲେ?
ସାର୍
କୋଉଠି?
ଫତେଗଡ଼ର ବର୍ଡରିଂ ପିଏସ୍ ହଉଛି ବୋଲଗଡ଼ ପିଏସ୍। ସେଇ ଏରିଆ ସବୁ ସାର୍ ସର୍ଚ୍ଚ କରୁଛୁ।
Have you got any information where are the relatives house of the accused?
ସେଇ ଗାଁର ପାଖରେ ସବୁ ତାର ରିଲେଟିଭ ହାଉସେସ୍ ଅଛି। ସେଠି ଆମେ ସାର୍ ରେଡ୍ କରିଥିଲୁ। ଯାଇଛୁ ବି ହେଇଯିବ ସାର୍।
ପାଖରେ ତ ରହିବେନି, ଦୂରରେ କିଛି ନାହିଁ କୌଣସି ରିଲେଟିଭ୍ସ ହାଉସ୍?
ଦୂରରେ ସାର୍ ତାର ରିଲେଟିଭ ହାଉସ୍ କିଛି ନାହିଁ। ସିଡିଆର ମଗେଇଛୁ ସାର୍, ହେଇଯିବ ସାର୍। ଟିକେ ସର୍ଟ ପିରିୟଡ ଦେଇଦେଲେ ସାର୍ ହେଇଯିବ।
ଏ ପିଲା କଣ କରେ?
ଡ୍ରାଇଭର ସାର୍।
ତା ମାଲିକ ନିଜ ଗାଡି ନା?
ନାଇଁ, ସେ ହାୟର ଗାଡିରେ ଚଲାଏ।
ତା ମାଲିକ ସାଙ୍ଗରେ କି ଯୋଗାଯୋଗ ରଖୁନି?
ସେ ସାର୍ ବାଇ ପ୍ରଫେସନ ହଉଛି ଡ୍ରାଇଭର, କିନ୍ତୁ ବର୍ତ୍ତମାନ ସେ ଡ୍ରାଇଭିଂ ଛାଡି ଦେଇଛି। ଝିଅକୁ ଧରି ଆଡେ ସିଆଡେ ସାର୍ ବୁଲୁଛି। ହେଇଯିବ ସାର୍ ଏଇ ଭିତରେ।
ନାଇଁ, ଫଣ୍ଡ ତାର ଆକାଉଣ୍ଟ କୁ କିଛି ପଠଉନି?
ସାର୍ ଷ୍ଟେଟ ବ୍ୟାଙ୍କ ଆକାଉଣ୍ଟ ରୁ ଗୋଟେ ଟ୍ରାନଜାକ୍ସନ ହେଇଥିଲା ସାର୍।
ଘଟଣା ପରେ?
ହଁ ସାର୍। ଯୋଉଟା କି ତାର ସିଡିଆର ସାର୍ ମଗେଇଛୁ ସାର୍, ଆନାଲିସିସ୍ ଚାଲିଛି। ଆଉ ଭେରି ସର୍ଟ ପିରିୟଡରେ ରେସ୍କ୍ୟୁ ହେଇଯିବ। କେବଳ ବ୍ୟାଙ୍କ ଟ୍ରାନଜାକ୍ସନ ହିଁ ତାର ଗୋଟେ 79 ରୁପିଜ ସେ ଟ୍ରାନଜାକ୍ସନ କରିଥିଲା। ସେଟା
79 rupees?
ହଁ, ଓନ୍ଲି ଗୋଟେ ଭୁବନେଶ୍ୱରରୁ ଟ୍ରାନଜାକ୍ସନ ହେଇଛି। ସେ ଜାଗାକୁ ସାର୍ ଦିଥର ରେଡ୍ ଗଲୁଣି। ହେଇଯିବ, ତାର ସିଡିଆର ବି ମଗେଇ ଦେଇଛି। ସର୍ଟ ପିରିୟଡରେ ସାର୍ ରେସ୍କ୍ୟୁ ହେଇଯିବ।
Alright, Shraddha Naik, SI of Police, Fatehgad Police Station, Nayagarh, is present, and Land Council for the state has submitted the status report of Fatehgad PS case number 203 dated 9/9/2023 under section 363 of the Indian Penal Code, in which various steps taken by the investigating officer for rescue of the victim girl and for arrest of the accused has been enumerated. The copy of the status report has been furnished to the Land Council for the petitioner. The investigating officer submits that she may be granted some further period for carrying forward his the investigation and to do the needful. put up this matter in the 19th February 2024. The Land Council for the state shall produce the up-to-date case diary, so also obtain instruction about the further progress made in the case. Personal appearance of the so-and-so is dispensed with.
For the status report is concerned, no date has been mentioned on what date he has conducted any investigation.
Something has to be kept secret. That is there in the CD case diary. But once everything is disclosed and it is uploaded, they may know that where they are going, what they are. It's all right. Yes. Now we have urgent the case. Next.
Item 26.
So then one matter remains, that is item number 20. It is passed over, Mr. Das.
Miller. 20 हाँ गोटे पास होइছে জয়েন করছন্তি
Where is Mr. Pandey?
Pandey has gone to another court.
Where is that order which was just downloaded? Print out कर लो बरा. Is he joining? Just फाइल जो order टा दियो. Item number 20 टा Is he able to hear us?
কথা
बाहर चला बड़ा लाऊंगी.
সেটা নেট আসুনতলা দে ভার
You do one thing, Mr. Let him ask to remain present tomorrow in the virtual mode at 10:30, so that it can be taken up. And Mr. Pandey be informed that it will be taken up tomorrow. Just keep it that order which has been passed in the file. Yes.
Item 26.
Twenty-one 6/20/23 ପରେ ଆଉ ମ୍ୟାଟର ଆସିଥିଲା କି ଦେଖିଲେ? 21/2023 ଅର୍ଡର ସିଟ୍ ଦେଖନ୍ତୁ. ସେଇଟା କଣ ଅର୍ଡର କୋର୍ଟର ଅର୍ଡର କଣ ଏଟା? Yes, where is Mr. Sahu? Who is to place this matter on behalf of the state?
Yes, ma'am.
Mr. Tripathi?
Yes, sir.
Mr. Das, please intimate Mr. Sahu, let him place the FIR. Yes.
May I please?
Yes.
Yes, sir. Page 28. ମୋର ନାମ ସିସିଲିଆ ଡୁଙ୍ଗଡୁଙ୍ଗ, ସ୍ୱାମୀ କାମିଲି ଡୁଙ୍ଗ।
PW3.
Yes. ଥାନା ତଳସେରା ସୁନ୍ଦରଗଡ଼। ଆଜି ମଙ୍ଗଳବାର 14/2/98 ତାରିଖ ଦିନ ମୋର ପୁତୁରା ବୋହୂ ମୁନିକା ସାରେଙ୍କ ସହିତ
Monica is
ମୁନିକା
not
not examined. ମୁନିକା ସାରେଙ୍କ ସହିତ କିଞ୍ଜିରିକେଲା ଥାନାରେ ହାଜର ହୋଇ ମୋର ଏହି ମୌଖିକ ରିପୋର୍ଟ ଦେଉଛି କି ଯେ କିଞ୍ଜିରିକେଲା ଗାଜାପଡାର ମାକ୍ସିମସ୍ ସୋରେଙ୍ଗ ପିତା କାମିଲ ସୋରେଙ୍ଗ ପିତା କାମିଲ ସୋରେଙ୍ଗ ଆଜକୁ 1 ବର୍ଷ ହେବ ଆମ ପଡାର ଜାକ୍ରିୟାସ ଡୁଙ୍ଗଡୁଙ୍ଗଙ୍କ ଘରେ ଗୁତି ରହିଥିଲା। ଜାକ୍ରିୟାସ not examined. ଜାକ୍ରିୟାସ ଡୁଙ୍ଗଡୁଙ୍ଗ ଘରେ ଗୁତି ରହିଥିଲା। ସେ ଗୁତି ରହିବା ସମୟ ଭିତରେ ମୋର ଝିଅ କୁମୁଦିନୀ ଡୁଙ୍ଗଡୁଙ୍ଗ ସହିତ ଗୁପ୍ତ ପ୍ରେମ ରଖିଥିଲା। ସହିତ ଗୁପ୍ତ ପ୍ରେମ ରଖିଥିଲା। ତାର ଆଡୁ ମୋର ଝିଅ 7-8 ମାସ ଗର୍ଭ ହେବାର ଜାଣିବା ପରେ ଆମ୍ଭେ ଆମର ଜାତି ସମାଜ 8/2/98 ତାରିଖ ରବିବାର ଦିନ ଡକାଇଥିଲୁ। ଉକ୍ତ ସଭାରେ ଆମ ପଡାର ଜାକ୍ରିୟାସ ଡୁଙ୍ଗଡୁଙ୍ଗ, ଶ୍ରୀନିବାସ କିଡୋ is not examined. ଶ୍ରୀନିବାସ କିଡୋ, ଲୁଇସ୍ ଡୁଙ୍ଗଡୁଙ୍ଗ ଓ ଅନ୍ୟମାନେ ଏବଂ କିଞ୍ଜିରିକେଳା ଲୁଇସ୍ no Miller. ଲୁଇସ୍ କିଞ୍ଜିରିକେଲାର ବିପିନ ସୋରେଙ୍ଗ, ବିପିନ not examined. ଇସାକ ସୋରେଙ୍ଗ he also not examined. ମାନେ ଉପସ୍ଥିତ ଥିଲେ। ଉକ୍ତ ସଭାରେ ମାକ୍ସିମସ୍ ସୋରେଙ୍ଗ ଓ ମୋର ଝିଅ କୁମୁଦିନୀ ଉପସ୍ଥିତ ଥାଇ ଜାତି ସମାଜ ଅନୁସାରେ ଏକାଠି ସ୍ୱାମୀ ସ୍ତ୍ରୀ ହୋଇ ରହିବୁ ବୋଲି କହିବାରେ ଉପସ୍ଥିତ ଭଦ୍ରବ୍ୟକ୍ତି ମାନେ ଏକ ଫଇସଲା କରିଥିଲେ। ଉକ୍ତ ଫଇସଲା ଅନୁସାରେ ମାକ୍ସିମମ୍ ସୋରେଙ୍ଗ, ମୋର ଝିଅ କୁମୁଦିନୀ ଉଭୟ ଆମ ଘରେ 2-3 ଦିନ ରହିଲେ। 11/2/98 ତାରିଖ ଦିନ ପ୍ରାୟ 11ଟା ସମୟରେ ମାକ୍ସିମସ୍ ମୋ ଝିଅକୁ ସାଙ୍ଗରେ ଧରି ତଳସରା ଫାଟକ ପାଖରୁ କିଞ୍ଜିରିକେଲାକୁ ବସରେ ବସି ଆସିଲେ। ମୋର ଝିଅ ତା ସାଙ୍ଗରେ ସେରେ ଚାଉଳ, 110 ଟଙ୍କା, 10 ଖଣ୍ଡ ଶାଢୀ, 4ଟି ସାୟା, କେତୋଟି ଜ୍ୟାକେଟ ବିଭିନ୍ନ ରଙ୍ଗର, ଗୋଟିଏ ସୁତି ବେଗ ଓ ଗୋଟେ ପ୍ଲାଷ୍ଟିକ ବେଗ ଧରିକି ଆସିଥିଲା। ମୁଁ ବସଷ୍ଟାଣ୍ଡ ପର୍ଯ୍ୟନ୍ତ ସେମାନଙ୍କୁ ଛାଡିବାକୁ ଆସିଥିଲି। ଆଜି 24/2/98 ତାରିଖ ମଙ୍ଗଳବାର ଦିନ ସକାଳେ ମୁଁ ମୋ ପୁତୁରା ବୋହୂକୁ ସାଙ୍ଗରେ ଧରି ମୋ ଝିଅକୁ ଦେଖିବା ପାଇଁ କିଞ୍ଜିରିକେଲା ଗାଜାପଡା ଆସିଥିଲି। ଏହି ସମୟରେ ମୁଁ ଗାଜାପଡାର ରବର୍ଟ ଟପନଙ୍କ ସହିତ ଘର ସାମ୍ନା ରାସ୍ତାରେ ରବର୍ଟ ଟପନ ଘର ସାମ୍ନା ରାସ୍ତା ଉପରେ ଶୁଣିବାକୁ ପାଇଲି ଯେ ଗୋଟିଏ ସ୍ତ୍ରୀଲୋକ ଓ ଗୋଟିଏ ଛୁଆ ଚିଲଡେଗା ମୌଜାର ଡୁମେରଗୁଡା ପଡାରେ ଉଦ୍ଧବ୍ଧ ଦଣ୍ଡସେନଙ୍କ ବାହାର ଜମି ଭିତରେ ଥିବା କୂଅରେ ଭାସୁଛି। ମୋ ମନରେ ସନ୍ଦେହ ହେବାରୁ ମୁଁ ନିଜେ ଯାଇ ଜମିର ମାଲିକ ଓ ଅନ୍ୟମାନଙ୍କ ସହାୟତାରେ କୂଅ ପାଣି ଭିତରୁ ବାହାର କରି ଦେଖିବା ପରେ ମୋ ଝିଅକୁ ଚିହ୍ନି ପାଇଲି। ମୋ ଝିଅ ବେକ ଓ ଅଣ୍ଟା କପଡା ସହିତ ବଡ ବଡ ପଥର ବନ୍ଧା ହୋଇଥିଲା। ମୋ ଝିଅର ମୁହଁ ପେଟ ପଚି ଫୁଲି ଯାଇଛି ଓ ଗନ୍ଧ ହେଉଛି। ମୋ ଝିଅ ପରିସ୍ରା ଜାଗାରେ ଜନ୍ମ ଦେଇଥିବା ଫୁଲ ଫୁଟା ଦାଗ ରହିଥିଲା ଏବଂ ସେ ଛୁଆଟି ଅନ୍ୟପଟେ ମରି ପଡି ଭାସୁଥିଲା। ଏଣୁ ମୁଁ ମୋ ଝିଅ ଏପରି ଅବସ୍ଥା ଦେଖି ଜାଣିପାରୁଛି ଯେ ମୋ ଝିଅକୁ ମାକ୍ସିମମ୍ ସୋରେଙ୍ଗ 11/2/98 ତାରିଖ ଦିନ ଆମ ଗାଁରୁ ଆଣି ତାକୁ ତାର ଛୁଆକୁ ଜୀବନରେ ମାରି ଦେହରେ ପଥର ବାନ୍ଧି କୂଅ ଭିତରେ ପକେଇ ଦେଇଛି। ଏଣୁ ଏହି ମୌଖିକ ରିପୋର୍ଟ କରିକି ଏହାର ତଦନ୍ତ କରାଯାଉ। ପଢି ଶୁଣି ଜାଣି ମୋ ଟିପ ଚିହ୍ନ ଦେଲି।
So that means there was some illicit relationship between the appellant and the deceased.
Yes, my lord.
On account of which the deceased became pregnant for 7 to 8 months. When it came to the knowledge of others, including her family members, a meeting was convened, and it was decided that they would live together as husband and wife.
Yes, my lord.
Then both of them stayed in the house of the informant
For 2-3
for
days.
2 to 3 days. Then on 11th, both of them went.
Yes, my lord.
And the lady carried something with her. Then after about 13 days,
13 days.
right?
Yes.
13 days, informant along with another went to meet the deceased. But on the way, they got this information that a dead body was floating in the
Floating in the
right,
well.
along with a child, the baby. Then they went there. The dead body was found to be that of the deceased, and the child dead body was there. All these things. So this maybe case is based on circumstantial evidence. Okay, let us see that what are this where the circumstances have been. Okay. Yeah, you come to
May I, my lord?
yeah.
I called Mr. S.K.SAHOO. He is informing that whether brief is with him or he has already someone taken the brief.
Who has taken the brief?
Kalam coach 5 minutes only. He told
No,
me.
no, it's all right.
And
We are
27 is Mr. Sasmita Patnaik is there also.
No, it's all right. Let us go for
PW3 mirror. Informant. I know the accused.
No, you come to the paragraph number 10 of the judgment.
Yes,
So
madam.
that we can know that what are the, because that is the, all the circumstances have been enumerated there. What are the circumstances in the case? Then we will go to the evidence.
Yes, madam.
Please come to page number 9, paragraph 10.
Yes, madam. In the instance case, the following circumstance, according to the prosecution, all ringly points towards the guilt of the accused. The accused had illicit love affairs with the deceased Kumudini, and the deceased had become pregnant through him. B. The accused had admitted his relationship with the deceased and agreed to keep her as his wife, and a written document was prepared to that effect. C. The accused stayed in the house of the deceased for few days, and thereafter the deceased left her house with the accused together with her belongings. D. The dead body of the deceased Kumudini and the dead body of the baby born to her were found lying in the well, which were identified by the mother of the deceased Kumudini. E. The accused was missing from the village, and a couple of days before the recovery of the dead bodies from the well, he had been seen at Sundargarh bus stand, wharf with a chadar and holding an airbag. F. The accused had arrested in Mumbai, where he was working for some time with a fake name. G. The accused, while in the custody of the police, gave recovery of the wearing apparels of the deceased, which she had bought with her while leaving her house. H. The doctor who had conducted PM examination opined that there are antemortem injuries on the chest and neck of the deceased Kumudini, which suggests pressure over the chest and side of the neck, which might have led to asphyxia, and the death of the female child might have occurred with the death of her mother, and the baby might have been expelled out of the uterus due to decomposition.
Okay, so these are the circumstances.
Yes.
Now you are reading that
Informant
that is PW
3 at page 46. I know accused Maximus, deceased Kumudini was my daughter. The occurrence took place about 6 years back. The accused was working as a field servant of one Zacharias of village Talsara. Due to relationship with the deceased, my daughter became pregnant. But as the accused did not marry her as per his promise, a meeting was convened in our village where both of them agreed to marry. The accused also agreed to accept my daughter as his wife. Thereafter, my daughter stayed with me, and the accused went to the house of Zakaria. About 3 days thereafter, both my daughter and accused Zakaria proceeded to the village of the accused, Kinjirikela. On that day, I went to see them at Talsara Phatak, where they boarded a bus. About 2 weeks thereafter, I went to Kinjirikela to see my daughter and reached there or not. Before that, I had not received any information about her reaching village Kinjirikela. At village Kinjirikela, I was informed that a dead body was lying and I should see if it belonged to my daughter. Hence, I went to Telijor, where I found the dead body of my deceased daughter. I could identify her dead body. The place where the dead body of my deceased daughter was lying was not approachable by any bus or other vehicle, and one has to reach there by walk. At first, on arriving the village Kinjirikela, I went to the house of the accused Maximus, but he was not present. Then I lodged an oral report before the OIC Kinjirikela police station. I was examined by the police. When I saw the dead body of the deceased, I found that the child she had carried in her womb had come out. The dead body of the newborn child was also lying there.
No, but this जो पुओ भितर पड़ीथिला बोली जोटा एफआईआर रे कहला
Again.
that is I think that is missing from his evidence. About 2 weeks thereafter, I went to Kinjirikela to see if my daughter had reached there or not. Before that, I had not received any information about okay. At village Kinjirikela, I was informed that a dead body was lying. Acha. I should see it if it belonged to my daughter. Hence, I went to so where I found the dead body. I put so say you ପୁଅ ପାର୍ଟଟା କହିନି ଯୋଉଟା କି ଏଫଆଇଆର ରେ ବୋଧେ
Yes,
କହିଥିଲା ଯେ ପୁଅ ଭିତରେ ମୋର ମନରେ ସନ୍ଦେହ ହବାରୁ ମୁଁ ଯାଇ ଜମି ମାଲିକ ଅନ୍ୟମାନଙ୍କ ସହାୟତାରେ ପୁଅ ପାଣି ଭିତରୁ ବାହାର କରି ଦେଖିବାରେ ମୋର ଝିଅକୁ ଚିହ୍ନି ପାରିଲି ଓ ଝିଅର ବେକରେ ସୋଆଂଶ ବନ୍ଧା ହୋଇଥିଲା. So other things he has almost stated that
Yes,
about that illicit love affair, then the deceased becoming getting pregnant, then about the meeting was convened
Yes,
in the village, and where the accused agreed to accept the deceased as his wife. Then few days the daughter stayed with the informant, and the appellant stayed in the house of Jackeries. Thereafter, they proceeded. Okay.
yes, ma'am.
Now you come to the, let us see what has been elicited in the cross-examination.
Cross-examination.
Yeah.
I had 5 daughters, including the deceased. Deceased was the 4th child. All of them except the deceased were married. The deceased had 1 daughter.
The deceased had 1 daughter,
whose name is Malin. She is about 7, 8 years at present. That daughter was born out of illicit relationship. I cannot say who was the father of that child. We were making arrangement to get Kumudini married. There was a proposal from the village Kurei. The name of the boy with whom marriage was fixed is Binu. He was not visiting my deceased daughter Kumudini. The house of Zacharias
deceased na hauchi Kumudini pura?
Yes, Kumudini.
Just a minute.
The house of Zachariah, with whom the accused was working as a field servant situated near my house. The accused was residing in his house and was also taking his meals there. The said Zachariah is my Dedasura. I was not working as a laborer in the house of Zakaria. We do not possess any landed property.
kaha evidence record heji eta this man is a eta kon puruଷ ଲୋକଟା ତି ଶିଶିଳା
The mother of the deceased,
Rita.
Cecilia.
just a minute
I'm son of late.
ଶିଶିଳା ହଉଛି ହଁ it's a lady right ସ୍ୱାମୀ ହଉଛି late Kamil so this is a lady right
Yeah.
so ଏଟାକୁ ଲେଖିବା କଥା I am son of କଣ ଲେଖା ଏଇଟା I am the wife of କରିବା କଥା see that was the confusion
Yes, ma'am.
so this I thought that he is the father so this is the mother of the deceased all right okay ଏଇ ଯୋଉଟା କହିଲା the deceased had one daughter and whose name is Melanie.
Yes.
She is aged about 8 years at present. That daughter was born out of an illicit relationship. I cannot say who was the father of that child. We are making arrangements to get Kumudini married. That means with somebody else she had earlier relationship and then a child was born out of that illicit relationship.
Yes.
Perhaps thereafter this
Incident took
relationship
place.
developed with the appellant and she became pregnant again.
Yes.
That is how she has stated. All right. Read from paragraph 5 once again.
The house of Zachariah with whom the accused was working as a field servant situates near my house. The accused was residing in his house and was also taking his meals there. The said Zachariah is my Detsura. I was not working as a laborer in the house of Zachariah. We do not possess any landed property and we live on labor work. I was present in the meeting which was called by my son. I had 3 sons. They are Ramu, Sudhir, and Anulus. About 5 months prior to the meeting, we knew about the pregnancy of my daughter. In those 5 months, we have not made any report in the police station. A document was prepared in the village meeting. I cannot say who prepared the same. I cannot read and write. About 60% had assembled in the meeting. My son were also present. I do not remember whether I gave my LTI on the document or not. My son gave their signature. I cannot say how many persons signed that document. Villagers of Kinjirikela and Tolsara were present there. I cannot say whether the contents of the documents were read over or not. In that meeting, the boy was asked first, then the girl was asked. In that meeting, the accused agreed to accept the deceased as wife. The deceased also agreed to remain as his wife. Then both of them said their namaskar to the elders. I cannot say if the gathering forced the accused to accept the deceased as his wife. I have not given any gift to the deceased at the time of her marriage. After the meeting, both of them did not start living together. To my
chief ରେ ମଧ୍ୟ କହିଛି
କହିଛି
କାରଣ but FIR story ଟିକେ different ଥିଲା FIR story ଟା ହଉଛି ଯେ ସେମାନେ ରହିଲେ ବୋଧେ ଏକାଠି 2-3 ଦିନ ଆଉଥରେ ଆସିଲେ ସେ ଲାଇନ ଟାକୁ ଉକ୍ତ ସଭାରେ ଅନ୍ୟମାନେ ଗଲେ ଆମେ ଏକାଠି ରହିବୁ ବୋଲି ଉକ୍ତ ଫଇସଲା ଅନୁସାରେ ଏଇ ଯୋଉଟା ଲାଇନ କହୁଛି page 28 ରେ last line ଉକ୍ତ ଫଇସଲା ଅନୁସାରେ ମାର୍କିସ୍ ସୋରେଙ୍ଗ means appellant and କୁମୁଦିନି means deceased ଉଭୟ ଆମ ଘରେ 2-3 ଦିନ ରହିଲେ ଯୋଉଟା କି
ସେଟା ଯୋଉ ଇଏରେ ଡିପୋଜିସନ ରେ କହୁଛି ଇଏର ଝିଅ ରହିଲା ସେ
ତା ଘରେ ଏଠି ମଧ୍ୟ ସେଇଆ କହୁଛି ଯେ after the meeting both of them did not start living together. Continue.
Yes. After the meeting, both of them did not start living together. To my knowledge, till the death of the deceased, both of them have not started living together.
Because thereafter they left na 11 तारीख रे पळेले तापर obviously आर
knowledge नाही किछि
it's all right. Then
the distance between my house and Talsara Phatak would be half koso.
ତଳସରା ଫାଟକ ମାନେ କୋଉଟା ଯୋଉଠି
ଯୋଉଠି
ବସ୍
ଛାଡିଲା ବସ ରେ ଛାଡିଲେ ତାକୁ
ଆଉ ଟିକେ ଆସିଲେ ସେଠି କୋଉଠି ଛାଡିଲା ତ କହୁଛି
ସେ
ଆଚ୍ଛା
ଫାଟକ ପାଖରେ ଛାଡିଲା ପା କହିଲେ।
କୋଉଠି ସେଟା କହିଲା proceeded on that day
ପେଜ 47
ତଳସରା ଫାଟକ ଠିକ ଅଛି ଓକେ ସେଇଠି ଯାଇକି ତାଙ୍କୁ ବସ ରେ ସେ ବୋର୍ଡେଡ
ବସରେ
ପେଜ 47 ର ଫାର୍ଷ୍ଟ ଲାଇନ ଟା ହଁ କୁହନ୍ତୁ
I alone saw them off where we are coming to my house to the
I
fatak.
alone saw them off
Yes. When we are coming to my house to the fatak, we did not meet anybody. Some stranger were present at the fatak. Maximus arrived at the fatak before us as he went in a bicycle. I did not talk Maximus at the spot. In the intervening 3 days between the meeting and the day when I saw them off, I had not talked to Maximus. On being requested by Kumudini, I accompanied her to the fatak. Kumudini told me that she will go with the Maximus. That day, I did not reveal this fact that Kumudini told before me that they shall proceeded to Kinjirikela before other residents of our village.
ଅନ୍ୟ କାହା ପାଖରେ
କାହା
ଏମାନେ
କହିନି,
କିଞ୍ଜିରି କେଲାକୁ ଯାଉଛନ୍ତି ବୋଲି କହିକିନି ଗଲେ ବୋଲି ଏ କଥା ଇଏ କାହାକୁ ରିଭିଲ କରି
During her pregnancy, my daughter was never taken to any doctor for her test or treatment. They boarded a bus whose name I cannot say at the Talsara Fatak. Then I returned home. I did not meet anybody on the way. I told about the departure of my daughter and the accused to my son. I told this fact to Zakaria. I did not tell it to anybody else. The distance between Kinjirikela and our village is long, and therefore the bus takes 16 rupees fare for the journey. At the Fatak, we waited for 1 hour for a bus. In that 1 hour wait, the accused did not talk with my daughter. I went to Kinjirikela for the first time. I walked the distance. It took half an hour to reach Kinjirikela. I was informed about the discovery of the dead body by the police at Kinjirikela, Girijapada. At that time, Manika was present with me. Only after the receipt of information about the discovery of dead body, I went to the police station. When I saw the dead body, it was lying in an open place. I cannot say where from the dead body was taken and who took it out. At the time of my seeing the dead body was in swollen condition, and it was difficult to identify the same. I could identify the same from the wearing apparels. Her salwar and sari were wrapped around her body. I had been to the house of Maximus to meet his mother. It is not a fact that Maximus did not bring my daughter from Talsera. It is not a fact that my daughter was pregnant by the accused, that no meeting was convened, and that the accused agreed to accept my daughter as his wife. It is not a fact that I am deposing falsely.
So this witness was stated about leaving the both of them together, and they went in they boarded a
bus.
So that evidence is it getting support from other evidence?
Yes, that
Because he has stated that I have disclosed about the same
yes,
to not only to my sons, obviously, and to also the Jaccrias, means the place where this appellant was working. The thing is that Mr.
Yes,
Tripathi,
yes,
if 11 is the date, 11th February 1998 is the date when they were last seen together
yes,
in a bus stand. The dead body was found at a totally different place, right? And of course, in the FIR, it is stated that it is from a well. but he has stated that it was lying in
In
open
open
place,
place.
and he though he stated that ମୁଁ ନିଜେ ଦେଖିଲି କୂଅ ଭିତରେ ପଡିଥିଲା ଆମେ ତାକୁ ବାହାର କରି ଆଣିଲୁ ପାଣି ଭିତରୁ, but in the evidence he has stated that I got the information from the police
Yes.
about the discovery of the dead body. Then I went there and found that it was in an open place. So now you see the gap is almost 11 and 24, 13 days gap is there. Is there any evidence that after 11th they stayed together at any particular place, either in the house of the accused or anywhere? Because when you consider the principle of last sin,
Last sin, yes.
then the law is that the last sin and the discovery of the dead body, there should be proximate link. Okay? Because if the time gap is long, the other persons coming in contact with the deceased cannot be ruled out. तो जड़े लोक को मनकर कटक रे आज तमे देखिल तार 10 दिन पर तार डेड बॉडी पुरी रु मिलला, आक्यूज संगे डिसीज को देखाला कटक रे 10 दिन पर तार डेड बॉडी पुरी सी बीच पाखरे मिलला, तो इट कैनॉट बी सेड टू बी ए लास्ट सीन. जो जगार देखाई से जगार एमती गोटे पाखापाखी जगार देखिले जोटि कि अन्य मानकर स्कोप जदि नथिबो संस्पर्श रे आसीबाकू, then it can be used as last sin.
Yes.
But where the gap is about 13 days, 11/2/98 रे सेमाने बस रे गले तलसरा फाटकू, तापरे सेमाने कोठी रहिले, एकाठी रहितिले कि नाही, तापरे गोटे डेड बॉडी मिलिला, पुओरु मिलिला कि जहाँ भी हो मिलिला, सेटा होची डिसीज रो छुआटा भी पड़थिला. तेणु एठी सेही सर्कमस्टांस को केते दूर बाकी आउ जो जिनस गुड़ा का आपण कहचंदी, सपोज लेटस इट इज एक्सेप्टेड दैट तांको भितरे इलिसिट रिलेशनशिप थिला आउ प्रेग्नेंट थिला झियोटा, एवं तापरे जो डेड बॉडी मिलिला तापरे अपेलेंट रो आउ किछि पत्ता मिलिलानी. अपेलेंट रो डेड बॉडी मिलिला, ए जो अपेलेंट गोटे मुंबई रे गोटे को जगह रे काम करथिला
In disguise.
हां,
In fake name.
हां फेक नेम सेटू आसिला, एवं पीएम रिपोर्ट टा मध्ये होउची गोटे जे इट्स ए होमिसाइडल डेथ.
Yes.
राइट.
Yes.
वर्तमान एति की सर्कमस्टांस, तेनु मेन सर्कमस्टांस आपनकर आसुची लास्ट सीन.
Last sin. PW4, the brother Miller.
अच्छा देखियो आपण
Page 52.
Okay, no, this witness has been further cross-examined on recall. That is at page 51.
Yes, Miller.
So please place that.
It is a fact that I have not stated before the IO that after the meeting my daughter stayed with me and the
Just 51. Please place.
it is a fact that I have not stated before the IO that after the meeting my daughter stayed with me and the accused going to the house of Zakaria. It is a fact that I have mentioned in the FIR and also stated in 161 CRPC statement that after the meeting Maxima Soreng and my daughter Kumudini stayed in our house for 2 to 3 days, and 11/2/98 at about 11 a.m. Maximus took my daughter to Kinjirikela by boarding a bus from Talsera Fatak. At Kinjirikela, the Thana Babu told me my daughter is lying at that place and I should go to see her. I went to the police station on being called by Thana Babu. On the day the dead body was discovered. Prior to the discovery of the dead body, I had not gone to the police station. Only after discovery of the dead body, I had been to the police station. It is not a fact that I have mentioned in the FIR and stated before IO that as suspicious arose in my mind, I, along with the owner of the land and the other, brought out the dead body from the well and identified the same to be my daughter.
So these are the contradictions, though she has stated, but the main thing, what has been stated, which has not been shaken at all, is that the both the appellant and the deceased were left at the bus stand and they proceeded to Kinjirkela.
Yes.
And that bus stand is Talsara Fatak, right? So that part is still there, but that was on 11 to
11, yes.
1998. Okay, now you said that
PW4.
PW4. Okay.
Deceased Kumudini was my sister. I also know the accused Maximus Sureng, who was working as field servant at Zacharias. The occurrence took place in the year 98. There was illicit relationship between my sister and the accused. We could know
Just take pause for me. Mr. Das,
Akshay is coming.
Huh?
He is coming. ସେ ଚାରିଟା ଅକ୍ଷର ଥିଲେ ତ ଜଣେ କହିଲା ମୋର ନୁହେଁ ଆଉ ଜଣେ
ଅକ୍ଷର ସାହୁ ଲେଖା
ହଁ ଅକ୍ଷୟ ସାହୁ 4 ଜଣ ଅଛନ୍ତି I got him, he is coming.
No, 1 2 3 4 ସେମାନେ କରୁନାହାନ୍ତି
ନା
ଆଚ୍ଛା ଇଏ ରାଇଟ୍ ଅକ୍ଷୟ ସାହୁ ଆସୁଛନ୍ତି
ଆଜ୍ଞା
ଆଚ୍ଛା ହଉ ପ୍ଲିଜ କଣ୍ଟିନ୍ୟୁ
Yes. We could know the same when Kumudini became pregnant. Thereafter, a meeting was convened in our village, which was attended by the accused. The accused was at first refusing to accept Kumudini as his wife, but as the Sabha decided that he should keep her as his wife, he agreed. In the meeting, he also admitted that Kumudini had become pregnant by him. A document was prepared in the meeting reciting the fact of compromise. Both the accused and deceased put their LTI. The parties were directed to bear the cost of food for all the members of the Sabha. After the meeting, my sister resided in our house and accused resided in the house of Zacharias.
Same thing like his
Yes,
mother
mother.
stated. Okay.
3 days after the meeting, both the accused and the deceased left our village. My mother went to see them off. Accused Maximus took my sister to his house. After returning from the bus stand, my mother revealed before me that she saw them off. Few days thereafter, my mother went to the village Kinjrikela in search of my sister, where she learnt about the death of my sister. Thereafter, I have not seen Maximus in the village. I have seen the dead body of my deceased sister and also the dead body of a small child. Police held inquest in my presence and prepared inquest report Exhibit 3. 3/1 is my signature. Police also held inquest on the dead body of the small child.
just a moment.
Yes. Cross-examination.
Who went to the house of I see after my sister did not and in the house of
এটা বার করো মনুষ্কর্য Dancing together, look. Yes. Enter. Full cycle. The last scene important decision
Yes.
the last scene comes into play where the time gap between the point of time when the accused and the deceased were last seen alive and when the deceased was founded is so small that the possibility of any person other than the accused being the author of the crime becomes impossible. So, so this is one is Muhammad Azad, citation. So 2008, 15 SCC 449. One, the same. Yeah. 2011 CC Safe Jetty 1011 6 SC 640. CC 2003 volume 7 SCC 37 Patinala Babu Babu versus Babu eta other for lekha hoji the second important circumstantial evidence against the accused is that the accused and the deceased were last seen together. To put it tersely, both of them slept together by retiring to the room that night. Last seen together in legal parlance ordinarily refers to last seen together in the street, at a public place, or at any place frequented by the public. But here the last seen together is much more than that. The last seen together here is sleeping together inside the bolted room. It is in the evidence of PW3 and PW6 that they had dined together and the accused and deceased were closeted in a room at about 8:30 p.m. Thereafter, therefore, on the fateful day, the accused and the deceased were closeted in a bedroom at about 8:30. Is undisputed, and it is the accused alone who has to explain as to what happened, how his wife died. So they have distinguished.
Yes.
ଗୋଟେ ବାହାରେ ଦେଖା ହବା ଆଉ ଗୋଟେ ସ୍ୱାମୀ ସ୍ତ୍ରୀ ଗୋଟେ ରୁମ ରେ ଶୋଇବା ତା ପରଦିନ ତାର ଡେଡ ବଡି ମିଳିବା ଭିତରେ ଏ ଲାଷ୍ଟ ସିନ୍ ଭିତରେ ପାର୍ଥକ୍ୟ ଅଛି ଫାଷ୍ଟ ହଉଛି ଟାଇମ ଗ୍ୟାପ୍ another thing is the time gap ଯୋଉଟାକୁ ସେମାନେ କହୁଛନ୍ତି ଯେ କେବେ ସେମାନେ ଦେଖା ହେଲେ ଆଉ କେବେ ତାର ଡେଡ ବଡି ମିଳିଲା ସେଇଟାକୁ ସେ ଇଏ କରୁଛନ୍ତି so
ଆଉ ଗୋଟେ ବି ଜିନିଷ ରହିବ ଲାଷ୍ଟ ସିନରେ ସପୋଜ the spot ମାନେ occurrence place, suppose somebody has seen someone in one place, even though that body is found after 2 days or 3 days, so that can be a last in theory on that basis.
no ଆପଣଙ୍କୁ ଗୋଟେ ଏକ୍ସାମ୍ପଲ ମୁଁ ଦେଲି ବର୍ତ୍ତମାନ କଟକରେ X and Y ଦେଖା ହେଲେ ଆଜି 10 ଦିନ ପରେ Y ର ଡେଡ ବଡି ପୁରୀରେ
That is again my lord is right. I am
ଏ କେସ ରେ କଣ ହେଇଛି
ହଁ,
ଏ କେସ ରେ
ଏ କେସ ରେ
11 ତାରିଖ ଦିନ
13 ଦିନ ପରେ।
ସ୍ୱାମୀ ସ୍ତ୍ରୀ ବସ୍ ଷ୍ଟାଣ୍ଡ ରେ ବସ ରେ ଚଢିଲେ ତାପରେ ଯଦି ଆପଣଙ୍କର ଏବଂ ଗୋଟେ ଜାଗାକୁ ଗଲେ ଲେଟସ୍ ସେ ଜାଗା ନା ହଉଛି Y ଜାଗାରେ ସେମାନେ ଏକାଠି ରହୁଥିଲେ ଏ ଏଭିଡେନ୍ସ ଯଦି ଆପଣ
ଆସିଥାନ୍ତା then
ଆବଡ୍ୟୁସ କରିବେ ନାହିଁ ଏବଂ ଖାଲି Y ଜାଗାରୁ ବା ସେଇ Y ର ପାଖାପାଖି ଜାଗାରୁ ଗୋଟେ ତାର ସେଇ ଯୋଉ ଜଣଙ୍କର ଡେଡ ବଡି ମିଳିଲା can it be said that they were this last scene is the circumstance can be utilized to convict
because my another submission is my lord. Suppose two friends are two persons in love, they went away, then it has happened something different. Suppose this is a husband and wife man. They went in their last sin by someone. And after some days it was found. If the husband is responsible, not responsible, he should have registered a FIR against his somebody else.
No.
My wife is missing, or
this man had gone to क्वेश्चन होची से जो पंचशील नीति रे जोटा 84 सुप्रीम कोर्ट रे सरदार ब्रिचांद रे कहछंती जे whether that circumstance can be explained under any other hypothesis or not.
Correct.
Important. Accused explain करछि कि that is irrelevant.
Accused we are suppose my lord my submission
आपण एट देखुन जोटा कहिले ना सपोज या हेई पारे let us they went together ताकू छाड़िला तापरे सी तार बॉम्बे पळेला तार पैसा पत्र रोजगार करिया पे पळेला ता भितरे डिसीज्ड कहा केमती ही कि ताकू somebody has killed her that and threw the dead body in the well तेणु एठी these possibilities are there तेणु जो ठिकी अन्य हाइपोथेसिस रे किछि एक्सप्लेन करि पार नथिबो सेही भलिया सर्कमस्टेंस को तमे तांको एगेंस्ट रे व्यवहार करिवो जो सर्कमस्टेंस को अन्य accused explain करिछि कि न करिछि that's a different matter when the circumstance cannot be explained एठी जोटा गोटे एग्जांपल पे लास्ट सीन गोटे घर भितरे स्वामी स्त्री रहिले राति रे बेडरूम रे सकाळू डेड बॉडी मिलला हस्बैंड फेरार and it is a homicidal death of the accused so the accused is bound to explain तेणु एठी गोटे आपनकर जो गैप टा होउची 13 दिन रो गैप आपण पर्टिकुलरली आपण एविडेंस आणु ना जे से माने जाई किनी से जो जगह को जाईथिले किजरी केला ना कोन किंजरी केला सेठी से माने निजे कोठी रहिले अटल रहिले कि नाही हला एई जो एविडेंस जदी आपनकर लैकिंग करिवो merely because आपण बस स्टैंड रे गले एवं तापरे accused बॉम्बे रु ताको अरेस्ट हला he may have been fake name रे रहउथिला कि काम करथला जहा भी हो एतिक को can it be said apart from these circumstances कारण एगुडा को आमे let us say if we hold that तांकर illicit relationship थिला she was pregnant a meeting was held they also decided that we'll stay together as husband and wife एगुडा को सब अछि एवं डेथ ता मध्ये होमिसाइडल डेथ हला डेड बॉडी टे मिलला कोर मिलला कि कोर्ट मिलला जाना नै से जा भी हो देयर इज समथिंग बट ए जो मेन जो लिंक टा रहउछि आपण कोन कहले जदी गोटे लिंक भी ब्रेक करियो ताहाले चेन टा कंप्लीट हो तेनु चेन टा कंप्लीट होबा को एई टाइप रो केस रे एई जो सर्कमस्टेंस आ जो वाइटल लिंक माने दैट दे वर लास्ट सीन प्रायर टू द डेथ जोटा की एक्सप्लेन करि पानी एठी आपनकर जोटा से कहउचंदी जो टाइम गैप टा हे जाउची बिफोर 13 डेज तेनु एवं प्लेस इज टोटली डिफरेंट गोटे प्लेस रे आपनकर बस स्टैंड रे देखा हला आ गोटे जगह रे 13 दिन परे जनकर डेड बॉडी मिलिछि तेनु एठी आपनकर बर्तन कोन होची जे जो मानकर माइंड टा से टाइप रो हां से जाई थिबो सेठी जाई दी जन जाक रही थिबे तापरे से जेहेतु ये छुआ से ताकू हे तो मारी किन तादरे पक एउडा सब चलला सस्पिशियन चलला हाइपोथेसिस ए जिंस सब चलला तेनु एठी आपनकर that is the why it is circumstantial evidence so suspicion however may be strong cannot take the place of proof हला तेनु संदेह हेई पारे किंतु सस्पिशियन रु कोनोसी लोक को 302 रे
लाइफ
हां
Mother, we don't need to straight in that exemption chief. But last 2 weeks, after I went to see if my daughter had reached there or not. These also positive. That I had not received any information.
He has got no contact. You see, neither the father,
Mother.
nor the brothers have stated that any communication was received from either the deceased or the appellant that they were staying together at that particular place कारण से माने कहउचंती ये गला बस स्टैंड रे छाड़ दिया हैला मा तापर आउ किछि स्वर शब्द नाही 24 तारिख दिन 13 दिन परे ये खबर पाइला प्रथम रे सेठी कहला जे मु जाउथिली आकर एफआईआर स्टोरी है मु जने स्त्री लोक सांगे जाऊली कोडी माने गली सेठी देखिया
देखिए
मो
मो
झियो
झील केमती
केमिति
अच्छी
क्रॉस एग्जामिनेशन ने कहलानी मते पुलिस खबर देला डेड बॉडी तेणु खबर पाई मु पुलिस स्टेशन को गली से गाँ फा एटा टोटल डिफरेंट स्टोरी जोड़ा कि सेमाने आनी क्रॉस एग्जामिनेशन बाहर करी जे तमे एफआईआर रे कहिथिलो तमे आउ जनक संगे गल देखिबा पई तम झियो केमती अछि बोली whereas in the court during evidence he has stated that police मते हमको कहिला जे डेड बॉडी मिलची बोली तेणु मु पुलिस स्टेशन को गली ता पूर्वरु मु पुलिस स्टेशन को जाई नथि he said about that in paragraph 9 I was informed about the discovery of the dead body by the police at Kinjrikela तेणु only after receipt of the information about the discovery of the dead body I went to the police station I saw the dead body as it was lying in open place I cannot say where from the dead body was taken and
Yes.
who took it out এই জিনিসটা কমপ্লিটলি কন্ট্রারি টু দি এফআইআর কারণ এফআইআর রে কহিলা মু দেখিলি সে ডেড বডিটা ভাସୁথিলা କୂଅ ଭିତରେ ତାର ଛୁଆଟା ବି ଭାସୁଥିଲା ଆମେ ତାକୁ ପାଣି ଇଏ କରି ପାଣି ଭିତରୁ କାଢିଲୁ ତାପରେ ମୁଁ ଦେଖିଲି ଯେ ଏଇଟା ହଉଛି ମୋ ଝିଅର ଏବଂ ଛୁଆଟା ମଧ୍ୟ ଇଏ ତ ଏଠି ଆସିଗଲା ଯେ ପୋଲିସ ଖବର ଦେଲା ପୋଲିସ ଖବର ଦେଇକିନି ଇଏ ଗଲା ବେଳକୁ ଓପନ ଜାଗାରେ ପଡିଛି ସେ କହୁଛି ମୁଁ କହିପାରିବିନି ଯେ କିଏ ଡେଡ ବଡି କିଏ ବାହାର କଲା କେମିତି ଆସିଲା ଦିସ୍ ଇଜ କଣ୍ଟ୍ରାରି ତେଣୁ he has prior to has stated that she got no information from anybody that they were living together after the meeting both of them did not start living together distance between the my house and the Tolsara Phatak जो bus stand है सेटा होची half अधा कोसो I myself saw them up I alone saw them up when we are coming to my house at Phatak we did not meet any of these some strangers gala in the intervening 3 days once so I saw them up I had not talked to Gala on being requested I accompanied her to Phatak Mudin told that she will go to with maximum that day I did not reveal this fact to someone during they boarded the bus whose name I cannot say at Talsara Phatak. Then I returned home. I did not meet anybody. I told about the departure of my sponsor. I did not tell the distance between Kinjrikela and our village is long. And therefore the bus takes 16 rupees fare to the journey. At Phatak, we waited for 1 hour for the bus. In the 1 hour, taxis did not talk to me. I went to Kinjrikela for the first time. I walked the distance. It took me half an hour to reach Kinjrikela. I've been from there.
Very strange. You see, though doctor child, so she cannot say
Was the
who was the father of that child.
भाई भी तो कहूनी ना माने जो तार भाई जे
PW4
हाँ एमाने गला परे किसी लिंक तांको संगे
ना ना ना
And in the examination sheet also the brother, this PW number 4 has not stated, though he has stated that when his mother went to that place in search of our sister, his sister,
yes ma'am.
she found that his sister is dead. That a few days thereafter. Thereafter, I have not seen the maximum in the village. I have seen the dead body of my. On getting such information, he went to that place. That is not his statement. But he has stated, I have seen the dead body of my deceased sister and also the dead body of a small child. Police held inquest in my presence and prepared the inquest report.
come to the cross examination of that PW.
Yes ma'am. The dead body of the deceased was found in Telidega 10 to 12 days after their departure. I found the dead body of the deceased. My brother and other residents of our village had accompanied me. By the time I reached there, I found the
You
dead
see,
body.
the place where they went to reside,
Yes,
it is at Kinjirikela.
Kinjirikela.
Kinjirikela ରେ dead body ମିଳୁନି. Dead body ମିଳୁଛି ଗୋଟେ କଣ ଜାଗା ନା ହଉଛି ସେଟା ହଉଛି ତିଲଡେଗା
half kilometer away from the Kinjirikela road.
କୋଉଠି
ସେଇଟା ହଉଛି
ସେଟା କୋଉଠି ପାଇଲେ
ସେଇଟା
ହାଫ କିଲୋମିଟର ସେଇଟା କହୁଛି ତା ଇଏ କହୁଛି ନା ମାନେ ତା ମା କହୁଛି ଯେ ଯୋଉ ବସ୍ ଷ୍ଟାଣ୍ଡ ଟା ହଉଛି ଆମ ଘର ପାଖରୁ 1/2 କିଲୋମିଟର
yes, yes.
ଏଇ ଯୋଉ ଇଏ ସେଇଟା ନୁହେଁ କିଞ୍ଜିରିକେଲାକୁ ବସ ରେ ଗଲେ ବୋଲି ଇଏ କହୁଛି କୋଉଠୁ ନା ତଲସରା ଫାଟକରୁ କିନ୍ତୁ ଡେଡ ବଡି ମିଳିଲା
Yes,
ଆପଣଙ୍କର
PW1 କହୁଛି.
ହଁ କଣଟା
PW1 has paid with 38.
we'll come to that.
Yes,
Yes.
there also he has stated, I found the dead body of my sister lying outside on the ground here, a wall near that must be near a well.
Well,
50 to 60 persons were present there, including my mother and police personnel. I did not talk to my mother. We remained there for 30 minutes to 1 hour. I signed some documents and I signed on those documents. Then further prosecution. I was not examined by the police. Thereafter, I have not gone to the police station. My other had gone to the police station. It is not a fact that I have not stated before the IO that accused and the deceased remained for 2 to 3 days after the meeting in their respective houses.
it is not a fact that I have stated before police that after the meeting, both the deceased and the accused started residing together. It is not a fact that I have not stated before the IO that I saw Maximus and Kumudini proceeding towards Kinjirikela. One Nicholas scribed the Punch Faisala. Myself, my brother, and my mother were present in the meeting. I have not signed the said document. The document
But mother has said that all my sons, those who are present, have scribed
signed the document.
Yes.
Yes. I have not signed the document. The document was kept in the custody of Sylvanus Kido. A copy of the same was also sent to the village Kinjirikela. Both the side were fined 100 rupees. Both the side paid the fine amount. My mother went to police station where I accompanied the dead body of the deceased, which was escorted to the district headquarters hospital Sundargarh by some police constable. The police officer called my mother to the police station. She was called for inquiry to this murder. I came to Kinjirikela from Talsara on being called by police. My mother came to Kinjirikela 2 or 3 hours before me. It is not a fact that no meeting was convened, that my sister was not pregnant by the accused, and that I am deposing falsehood. It is not a fact that we forced the accused to keep deceased as his legally wife, and for that reason both of them never reside as husband and wife.
When the appellant was arrested,
Highway 98 man. And apprehended on 8/8/98, that was running page 80. The IO examination, para 7.
after my arrival, On 8/8, the appellant was forwarded to the court at Mumbai. I made a prayer for issuing transit warrant to bring the accused to Mumbai. In course of investigation at Mumbai, I examined so and so. These witnesses stated that the accused was working in the wine shop, and identity card with photograph it issued in my favor that the accused was working in a hotel by giving his identity as Mukesh. I obtained the Xerox copy of the master roll back in the month of so and so after showing the. So, date of occurrence is February 98. And the appellant was arrested in August
8.
ଗୋଟେ ସିଜିଅର ଲିଷ୍ଟ ଅଛି जोटा कि मार्क ହେଇଛି एग्जिबिट 5 ରେ ସେଟା ହଉଛି wearing apparels of the deceased were seized on the information given by so and so the accused. After the accused was arrested, ସେଠି ସେ evidence ଟା ଆସିଛି ଆପଣଙ୍କର paragraph number 10 ରେ 10 ଟା ପଢନ୍ତୁ page 81 your evidence.
On 12/8/98, during my further interrogation at the PS, and while in my custody, the accused confessed his guilty and further stated that he had threw a bag containing the sari, a sweater, saya, and blouse of the deceased together with a stone into the well. I recorded the statement of the accused under Section 37 of the Indian
27 of the
Indian Evidence Act in presence of the witness and obtained his LTI thereon. The accused led us to that well, and the bag containing the clothes of the deceased was brought out of the well. I effected seizure of the said clothes and the bags in presence of the witness and obtained the LTI of the accused on the seizure list. Exhibit 5 is the seizure list, and Exhibit 5/2 is my signature. Exhibit 20 is the statement of the accused recorded under Section 27 of the Indian Evidence Act. On the same day, forwarded the accused to the court along with the connected papers.
ଏଇ ଯୋଉ 6 ମାସ ପରେ
yes ma'am.
ଯୋଉ ଘଟଣାର ଗୋଟେ ସେ ଇଏ ଦେଖଉଛି ସେ ଯୋଉ ସିଜିଅର ଲିଷ୍ଟଟା ऐसे फाइल टा देलो एग्जिबिट एलसीआर तो ट्रायल कोर्ट रिकॉर्ड डेट होगी 12/8/18 ଜିନିଷ ଜବତ ହେଇଛି ଏଗୁଡା ଗୋଲାପୀ ରଙ୍ଗର ଫୁଲ ପକା ପଲିଷ୍ଟର ଶାଢୀ ସବୁଜ ରଙ୍ଗର ପଲିଷ୍ଟର ଫୁଲ ପକା ଶାଢୀ ଆଉ ଗୋଟେ ଶାଢୀ ଆଉ ଗୋଟେ ବ୍ଲାଉଜ ଆଉ ଗୋଟେ ସ୍ୱେଟର ଦେନ୍ ସାୟା then ଗୋଲାପୀ ରଙ୍ଗର ଲେଡି ଚପଲ ଗୋଟେ ଶୁଆନ୍ତୁ। ଏଇଟା ଲେଖା ହେଇଛି ଯେ ଉପରୋକ୍ତ ମକଦ୍ଦମା ତଦନ୍ତ ସମୟରେ circumstance of seizure ଅପରାଧ ସଂକ୍ରାନ୍ତରେ ପୋଲିସ ହେପାଜତରେ ଥାଇ ସୁଆଂଶୁ ଦିନ ରାତି ପ୍ରାୟ 9ଟା ସମୟରେ ସେ ତାର ସ୍ତ୍ରୀ ସୁଆଂଶୁକୁ ମାରି ଏଇ ଜିନିଷ ଗୁଡାକ ବ୍ୟାଗ ସହିତ କୂଅ ଭିତରେ ଲୁଚାଇ ରଖିଥିବାର ଦୋଷ ସ୍ୱୀକାର କରି ପୋଲିସ ଓ ସାକ୍ଷୀ ମାନଙ୍କର ଉପସ୍ଥିତିରେ କୂଅ ପାଖରୁ ବଢାଇ ଦେଇ ଦେଖେଇ ଦେଇ ତ କୂଅ ପାଣି ଭିତରୁ ସୁଆଂଶୁ ସାହାଯ୍ୟରେ ଖୋଜି ବାହାର କରି ସାକ୍ଷୀ ମାନଙ୍କ ସାମ୍ନାରେ ଜବତ କରାଗଲା। So this is the statement which has been given, but that part would be inadmissible because it is hit by section 25. So what was recovered at the instance of the
Yes.
This wearing apparels, okay?
Yes.
So some wearing apparels. Now the question is that some wearing apparels, jodi bhi accept हुए, some wearing apparels were recovered from inside a well on the basis of the statement of the appellant, which was recorded under section 27 of the Evidence Act. Question is now whether these wearing apparels were that of the deceased or not. So the best person would have been the mother of the deceased,
yes,
or any of the family members. So when the mother was examined, why the prosecution did not confront those wearing apparels for identification? And the IO stated where from the dead body was recovered. Come to the IO's evidence.
Yes.
Page 78.
78.
हाँ से registration कला परे
On that day, one Shishira Dungdung, wife of late Kamel Dungdung, appeared at PS and orally reported to the fact that accused Maxima Soren had killed her daughter Kumudini Dungdung and he had thrown her dead body into a well by trying the stone in the body of the deceased. I reduced the oral report of the complaint into writing and read over and explained in contents to her, and she out her thumb impression on the report after finding the contents to be true and correct. Exhibit 14 is the said FR and Exhibit 14/1 is my endorsement with signature. I drew up the formal FR. Exhibit 14/2 is my signature in the formal FR. I registered PS case number 8 dated 22/24/98 under section 302/201 IPC and took up investigation.
registration ହେଇଛି देखो information received is police station रे 2:30 रे.
Yes.
That is page number 26 formal FIR 24/2/98 2:30 रे information मिलिଛି ହେଲା तापर से ताको registration କରିଛି registration timing ମଧ୍ୟ ପଡିଛି.
Thereafter, I examined the complainant.
Then just a minute. Then he examined some of the witnesses, including the informant, and then proceeded to the spot. Spot re पहुंचला से 3:30 रे. Now you read it.
The spot of occurrence was cultivable land of one Uddhava Dansena in the village Dildeka Dumerguda. There was there was a well on the eastern side ridge of the said land which was full of water, and the dead body of the deceased was floating at the eastern side of the well, and the dead body of a baby was also floating at the eastern side of the well. Big stones were tied to the body of the deceased Kumudini. At a distance of 40 feet of the well towards the northeast, there was a big stone, and near it some broken bangles similar to those worn by the deceased on her hand were lying. I prepared a spot map in the crime details form. Exhibit 15 is that spot map. I examined Uddhav Dansena and Bhagwan Dansena who were present at the spot. Thereafter, I seized the broken bangles which were lying near the stone. Exhibit 6 is that seizure list, and Exhibit 6/2 is my signature. I guarded the spot along with the constable U.A. Laureate till arrival of the relatives of the deceased. On 25 to 98 at 6:30 a.m., I held inquest over the dead body that had been brought out of the well during the previous night. I prepared two separate inquest reports in respect of uh, each of the deceased. Exhibit 3 and 4 are those inquest report. Exhibit 3/4 and 4 by 3 are my signature thereon. I seized 4 numbers of granite stone boulders which were tied to the dead body of the deceased Kumudine and prepared seizure list. Exhibit 7 is that signature is that seizure list, and Exhibit 7/2 is my signature. Thereafter, I examined witnessed, namely Jacarissa Jacarissa Dungdung, Hilarus Kilo, Marshal Kiro, Sudhir Dungdung, Ramanus Dungdung. On the same day at 9 a.m., I sent the dead body of the deceased Kumdini and the female baby to District Headquarters Hospital, Sundargarh, for PM examination through one constable, UN Laria, and the relatives of the deceased also accompanied them. Thereafter, I searched for the accused but could not find him in the village. I also examined some of the witnesses of the village, namely Bipin Soren, Junus Topo, Ambrus Topo, Isaac Soren, and seized one Punch Faisalanama from Isaac Soren. Exhibit 1 is that Punch Faisalanama. Exhibit 2 is that seizure list by which Exhibit 1 was seized. Exhibit 2/3 is my signature on Exhibit 2. On 26 to...
Yes, just take pause for me. Mr. Tripathi, you mark it. FIR रे आसନ୍ତୁ page 29.
Yes, ma'am.
आगे देखନ୍ତୁ FIR टा केतेବେଳେ टाइम रे लॉज ହେଲା. Page 26 को आसନ୍ତୁ. चौबीस नंबर पेज रे देखिले गोटे कॉलम अछि.
Yes, ma'am.
इनफॉरमेशन रिसीव्ड 24/2/98 टाइम होची दिन 2:30 पाइले दिन 2:30 रे ए एफआईआर टा लॉज हेची हला एवं रजिस्टर्ड हेची. वर्तमान पळे आसंदु एफआईआर पेज नंबर 29.
Yes, ma'am.
जो स्त्री लोकटा आसुथिला मा इनफॉर्मेंट 24 तारिख दिन लास्ट 6 लाइन पढंतु. मो मनरे संदेह हबारु पेज 29 नो लास्ट 6 लाइन्स. मो मनरे संदेह हबारु पढंतु.
ମୋ ମନରେ ସନ୍ଦେହ ହେବାରୁ
जस्ट गो
ମୁଁ
स्लोली. हां
ନିଜେ ଯାଇ ଜମି ମାଲିକ ଓ ଅନ୍ୟମାନଙ୍କ ସହାୟତାରେ କୂଅ ପାଣି ଭିତରୁ ବାହାର କରି ଦେଖିବାରେ ମୋ ଝିଅକୁ ଚିହ୍ନି ପାରିଲି. ମୋ ଝିଅର ବେକ ଓ ଅଣ୍ଟାରେ କପଡା ସହିତ ବଡ ବଡ ପଥର ବନ୍ଧା ହୋଇଥିଲା. ମୋ ଝିଅ ମୁହଁ ପେଟ ପଚି ଫୁଲି ଯାଇଛି ଓ ଗନ୍ଧ ହଉଛି. ଏଟା
ଏଇଟା କେତେବେଳେ ହେଲା ସମୟ? ଏଇଟା ତା ମାନେ ଏଫଆଇଆର ହବା ପୂର୍ବରୁ
ସକାଳୁ କହୁଛି ସେ. ମୁଁ ଯାଉଥିଲି
ଏଫଆଇଆର ହବା ପୂର୍ବରୁ 2:30 ପୂର୍ବରୁ ଡେଡ୍ ବଡିଟା ଅଲରେଡି କୂଅ ଭିତରୁ ବାହାରି ସାରିଥିଲା ଏବଂ ଛୁଆଟାକୁ ବି ବାହାର କରିଥିଲେ. ତାପରେ ସେ ଚିହ୍ନିଲା. ରାଇଟ୍. ନାଉ ୟୁ କମ୍ ଟୁ ଦି ଏଭିଡେନ୍ସ ଅଫ ଦି ଆଇଓ ଯୋଉଟା ଆପଣ ବର୍ତ୍ତମାନ ପ୍ଲେସ୍ କରୁଥିଲେ. पेज नंबर 79 paragraph number 2.
On 25/2/98 at 6:30 a.m. I held inquest over the dead body that had been brought out of the well during the previous night.
ରାତିରେ ବାହାରିଛି. ଯଦି ଡେଡ୍ ବଡି ରାତିରେ ବାହାରିଛି ତାହେଲେ ଏଫଆଇଆର ରେ ଯେହେତୁ ଡେଡ୍ ବଡି କଥା ଉଲ୍ଲେଖ ହେଇଛି ତାହେଲେ it presupposes that the FIR was not lodged at 2:30 p.m. It was lodged subsequently
Yes.
and it has been antedated. କାରଣ ଡେଡ୍ ବଡିଟା 24 ତାରିଖ ଦିନ ରାତିରେ ଡେଡ୍ ବଡି ମିଳିଲା, କିନ୍ତୁ ଏଠି ଦିନ 2:30 ଅପରାହ୍ନରେ ଯୋଉ ଏଫଆଇଆର ଟା ଆପଣ କହୁଛନ୍ତି ଲଜ୍ ହେଇଛି ବୋଲି, ଯୋଉଠାରେ ଦେଖା ହେଇଛି ଯେ ଡେଡ୍ ବଡି ଅଲରେଡି ବାହାରି ଗଲାଣି କୂଅ ଭିତରୁ, ଛୁଆର ଡେଡ୍ ବଡି ବି ମିଳିଗଲାଣି, ଛୁଆର ଆଇଡେଣ୍ଟିଟି ବି ମିଳିଗଲାଣି, କିନ୍ତୁ ଇଏ କହୁଛି ମୁଁ ସ୍ପଟ ଭିଜିଟ କଲି ଏଫଆଇଆର ପରେ ଏବଂ ଏଫଆଇଆର ପରେ ଯାଇକି ସ୍ପଟ ଭିଜିଟ କଲି, କିନ୍ତୁ ଗାର୍ଡ କରିକି ରଖିଲି। ଦେନ୍ ନେକ୍ସଟ ଡେ 6:30 ମୁଁ ଇନକ୍ୱେଷ୍ଟ କଲି, ଆଉ ଡେଡ୍ ବଡିଟା ମିଳିଲା କୋଉ ଦିନ ନା 24 ତାରିଖ ଦିନ ରାତିରେ ମିଳିଲା। So that presupposes that ଯୋଉ ସମୟରେ ଇଏ ଦେଖେଇଛି ଏତେଲା ହେଇଛି ବୋଲି, ଏ ଏତେଲା ସେ ସମୟରେ ହେଇନି। ଏତେଲା ଡେଡ୍ ବଡି ମିଳିବା ପରେ, ଅର୍ଥାତ୍ ଆଟଲିଷ୍ଟ ଏତେଲା ହେଇଛି 25 ତାରିଖ ଦିନ, though it has been shown to have been registered on 24/2/1998.
Yes.
କାରଣ 24 ତାରିଖ ଦିନ ରାତିରେ ଯଦି ଡେଡ୍ ବଡି ମିଳିଲା, ଏଇଟା ଯଦି ଆଇଓର ଭର୍ସନ ହେଇଥାଏ, ତାହେଲେ
25 ତାରିଖ
ଇନଫର୍ମାଣ୍ଟ କେବେ ଲେଖିନଥାନ୍ତା ଯେ ମୁଁ ସକାଳେ ଯେତେବେଳେ ଯାଉଥିଲି ସେତେବେଳେ ଶୁଣିଲି ଏବଂ ଦେଖିଲି ଏଇଟା ଏମାନଙ୍କର ଗୋଟେ ପଡିଛି ଡେଡ୍ ବଡି ତା ଭିତରେ, କୂଅ ଭିତରେ, ଆମେ ତାକୁ ବାହାର କଲୁ, ବାହାର କରି ଦେଖିଲୁ ଏମିତି ଇଏ ହେଇଛି, ମୋ ଝିଅର ଡେଡ୍ ବଡି ଥିଲା, ତାପରେ ମୁଁ ଯାଇ ଦିନ 2:30 ଲଜ୍ କଲି। 2:30 ବେଳକୁ ଡେଡ୍ ବଡି ଟୋଟାଲ ମିଳି ନଥିଲା, ଡେଡ୍ ବଡି ମିଳିଲା ସେଦିନ ରାତିରେ ଯାଇ ମିଳିଲା, ତା ପରଦିନ ସକାଳେ ଇନକ୍ୱେଷ୍ଟ ହେଲା। So this statement of the IO is running contrary to what has been stated by the informant in the FIR.
ये 24 डेट कौची आयो कौची 25th
25th ରେ ଇନକ୍ୱେଷ୍ଟ ହେଲା, ତା ପରଦିନ ଇନକ୍ୱେଷ୍ଟ ହେଲା, କିନ୍ତୁ ସେଇଠି ସେ କହୁଛି 25 ତାରିଖ ଦିନ ମୁଁ ସକାଳ 6:30 ରେ ଇନକ୍ୱେଷ୍ଟ କଲି।
previous night ରେ
that had been brought out of the well during the previous night. କାରଣ ଆପଣ ଦେଖନ୍ତୁ ତା ପୂର୍ବରୁ ମଧ୍ୟ ଲାଇନ କହୁଛି, ଯେତେବେଳେ ସେ କୂଅ ପାଖକୁ ଗଲା, ଏଇ ଯୋଉ ଏଫଆଇଆର ପରେ ସେ କହୁଛି କୂଅ ପାଖକୁ ଗଲା, ସେ ଦେଖିଲା କୂଅ ପାଖରେ, କୂଅ ଭିତରେ ଫ୍ଲୋଟିଂ କରୁଛି ବୋଲି। 3:30 ରେ ଦେଖନ୍ତୁ, 3:30 ରେ ସ୍ପଟ ରେ ପହଞ୍ଚିଲା, ସେତେବେଳକୁ ଦେଖିଲା ଯେ କୂଅରେ ପାଣି ଭରା ହେଇକି ରହିଛି ଏବଂ ଡେଡ୍ ବଡି ଫ୍ଲୋଟିଂ କରୁଛି, ଛୋଟ ଛୁଆଟା ମଧ୍ୟ ଫ୍ଲୋଟିଂ କରୁଛି। Whereas the evidence in the FIR it is stated that they brought it out right
with the help of the villagers.
ତେଣୁ ଯଦି brought it out as per the evidence of the IO is on the night of 24/2/1998. So obviously this FIR was lost after that.
Yes.
But it has been stated to have been lost on 24/2/98
at 2:30. I went to the police station. I saw the dead body. It was lying on the floor.
Next is that 6 ମାସ ପରେ ଆପଣ କିଛି ଡେଡ୍ ବଡି ୱେରିଂ ଆପେରାଲ୍ସ ସେ ଯୋଉ କୂଅରୁ ମିଳିଲେ, ତ ବର୍ତ୍ତମାନ ସେଗୁଡାକ ଡିସିଜ୍ଡ ର କି ଆଉ କାହାର, ଆପଣ ଲିଙ୍କ ଆଣିବେ ତ ଡିସିଜ୍ କଣ ପାଇଁ ସେଟା ଆଣିଲେ, ଯେ ନାଇଁ ଇଏ ତାକୁ ନେଇକି ତା ଭିତରେ ପକେଇ ଦେଇଥିଲା, ତାପରେ ତାର ଡ୍ରେସ ପତ୍ର ଲୁଗାପଟା ମଧ୍ୟ ପକେଇ ଦେଇଥିଲା। ତେଣୁ ତାକୁ ପ୍ରମାଣ କରିବାକୁ ହେଲେ ଯେ ଏଇ ଲୁଗା ଗୁଡାକ ହଉଛି ଡିସିଜ୍ଡ ର, ତେଣୁ ଆପଣ प्रमाण करिथान्ते through the other persons like the mother
Yes, my lord.
or the, so you have not done that. What we want to show you that these are the missing links. Question is that unless we are satisfied that there is chain of circumstances complete one, and it is so complete that it does not leave any words except pointing out to the guilt of the accused,
Yes.
that it is the accused and accused alone who has committed the crime. ତେଣୁ ଏଇ ଭିତରେ ଯଦି ଆମେ satisfaction ନ ଆସିଲା ଏବଂ there is missing link in the chain of circumstance, then conviction cannot be sustained. ଆପଣଙ୍କର main circumstance ଏଇ case ରେ ରହୁଛି ଯେ ଦି ଜଣ ଯାକ ଗଲେ
Last seen together.
last seen together bus stand ରେ ଚଢିଲେ, ତାର 13 ଦିନ ପରେ ଡେଡ୍ ବଡି ଟେ ବାହାରିଲା କୂଅ ଭିତରୁ, ଏବଂ ଯୋଉ ଗାଁକୁ ଏମାନେ ଗଲେ ସେ ଗାଁରେ ଡେଡ୍ ବଡି ମିଳିନି.
No.
It is in a different village.
Different.
There is no evidence on record that after they boarded the bus, they went to that place, lived appellant were living together. So that is a vital piece of circumstance that should have been established. ଆପଣଙ୍କର evidence ମଧ୍ୟ ନାହିଁ ଯେ deceased କୌଣସି communication କରିଥିଲା ତା ମା ସହିତ, ତା ଭାଇ ସହିତ, ଯେ ମା ମୁଁ ଆଙ୍କ ସହିତ ଏଇ ଜାଗାରେ ରହୁଛି ବର୍ତ୍ତମାନ ଭଲରେ ଅଛି କି ଯାହା ବି ହଉ. ତେଣୁ where is the evidence that merely because they boarded the bus at one point of time and the dead body was recovered at another place after 13 days, can it be traced that it would be taken as a clinching evidence against the accused? So ସେଇଟା ହଉଛି ଆପଣଙ୍କର vital link. Let us say that ଅନ୍ୟ circumstance ଗୁଡାକ ଆପଣ establish କରିଛନ୍ତି about illicit relationship, becoming pregnant,
meeting
then,
was held.
meeting was held. Then let us say they ଆଉ ଗୋଟେ ଜାଗାରୁ ମିଳିଲା ଯୋଉ ବମ୍ବେରେ ଚାକିରି କରିଥିଲା, ତେଣୁ ଏଗୁଡାକ ଏବଂ is a forced homicidal death ହେଲା. But unless ସେଇ ଯୋଉ vital circumstance କୁ ଆପଣ ଯଦି establish ନ କରିବେ, how we will find that the chain is complete? ଯୋଉ circumstance ଟାକୁ ସେଠି ଆପଣ ସେ ଲର୍ନିଂ ଟ୍ରାଏଲ କୋର୍ଟ ତାକୁ ସମରାଇଜ କରିଛନ୍ତି ଆଟ ପେଜ ଯୋଉଟା କି ଆପଣ ଫେସ୍ କରୁଥିଲେ, that is page number 9 paragraph number 10 ରେ. Let us say this accused had illicit affair proved, accused admitted his relationship proved, accused stayed in the house of the accused for few days, this is disputed.
Disputed, yes.
Okay. And thereafter the deceased left the house of the accused together, this is admitted, let us say. এটা ধর prove ହେଇଛି ବୋଲି, admitted ନୁହେଁ ତ prove ହେଇଛି. The dead body of the deceased ଏଗୁଡାକ let us say prove ହେଇଛି. ଏଇ ଯୋଉ ଗୋଟେ circumstance ଆ ଭିତରେ miss କଲେ ଯୋଉଟା କି ନାହିଁ evidence ଆପଣଙ୍କ, that they were residing together after they left the village of the deceased.
Village, yes.
That would have been the most vital circumstance.
That is missing.
बाकी से पंच विटनेस गुड़ाक सब कहते मीटिंग है, there is no problem that पंच रे डिसाइड है या କହୁଛି ଯେ ତା ଆକ୍ୟୁଜ ଷ୍ଟେଟମେଣ୍ଟ କହୁଛି ହଁ ମୁଁ ବମ୍ବେରେ ହୋଟେଲ ମଦ ଦୋକାନରେ କାମ କରୁଥିଲି ଦ୍ୟାଟ୍ ଇଜ ଆଟ୍ ପେଜ 35 କିନ୍ତୁ ମୁଁ ମୁକେଶ ବୋଲି କହିନଥିଲି ଯୋଉ ଫେକ୍ ନେମ୍ କଥା କହୁଛନ୍ତି
Yes, sir.
ମୁଁ କୌଣସି ସ୍ୱୀକାରୋକ୍ତି ପୋଲିସ ପାଖରେ ଦେଇନାହିଁ ଯେହେତୁ କିଛି ଏଭିଡେନ୍ସ ନାହିଁ ଯେ ଆପଣ ଡିସିଜ୍ଡ ଘରୁ ଯିବା ପରେ ବା ତା ଗାଁରୁ ଯିବା ପରେ ତା ସହିତ ଆପଣ ଏଇ ଗାଁରେ ରହୁଥିଲେ ଏକାଠି ଏଭିଡେନ୍ସ ନାହିଁ ତ ଓବିୟସଲି କ୍ୱେଶ୍ଚିନ୍ ବି ସେ ଲାଇଟରେ ପଚରାଇନି
ନା
313 ଷ୍ଟେଟମେଣ୍ଟରେ Please come to page number 82. That is the IOS evidence.
yes, sir. Cross examination.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 line from the bottom. Page 82.
The case diary does not reveal the manner
11 line from the bottom.
There is no direct record to the effect that the accused and deceased Kumudin were living as husband and wife under one roof.
This is one of the vital circumstances.
Yes, ma'am. The photograph of accused had not been published in
ସେଗୁଡା ସେ ଅଲଗା କଥା।
yes, what ସେଇଟା ଗୋଟେ
ତାମାନେ ଆଇଓ ପାଖରେ ଟୋଟାଲି ଏଭିଡେନ୍ସ ହିଁ ନଥିଲା କୌଣସି ସାକ୍ଷୀର ନା ଡକୁମେଣ୍ଟାରୀ ଏଭିଡେନ୍ସ ଯେ ଏମାନେ ଏକାଠି ରହୁଥିଲେ
ରହୁଥିଲେ in
ଯୋଉଟା
one
କି ହଉଛି ଗୋଟେ ଭାଇଟାଲ ଫ୍ୟାକ୍ଟର ଏଇ ଟାଇପ ର କେସ୍ ଆଉ ବାକି ଏକାଠି ଆସିଲେ ଠିକ ଅଛି ବସ ରେ ଏକାଠି ଆସିଲେ ମା ତାଙ୍କୁ ଆଣି ଛାଡି ଦେଇ ଗଲା ବସ ଷ୍ଟାଣ୍ଡ ରେ ବଟ ତାପରେ ଏକାଠି ରହୁଥିବାର ଏଭିଡେନ୍ସ ଯଦି ନାହିଁ माने ये जो recording ହେଇଛି evidence जो bangles fangles of the wearing apparels of the deceased were recovered from
Yes,
the well.
yes.
How it is of the deceased? The जो ଲୋକଗୁଡା କହୁଛନ୍ତି ଆପଣଙ୍କର independent ସାକ୍ଷୀ ଗୁଡାକ how they know that it is of the deceased? ହଁ ଠିକ ଅଛି ମିଳିଲା ଲୁଗା ମିଳିଲା ଇଏ ମିଳିଲା ପୁଅ ଭିତରୁ ମିଳିଲା but it is of the deceased the best witness is
Mother.
mother ବା ତା ଭାଇ ସେମାନେ କହିପାରିଥାନ୍ତେ ଯଦି ସେମାନେ କହୁନାହାନ୍ତି ଏଇ ଟାଇପ ର ଗୋଟେ ସିଜିୟର ଲିଷ୍ଟରେ ପୋଷାକ ତାଙ୍କର ଇଏ ମିଳିଲା
Yes, ma'am.
we are not satisfied with that it's a case of
That one chain is missing.
that's it the appellant Maxi alias Maximus Soreng faced trial in the court of London Second Ad Hoc Additional Session Judge Sundargarh in Sessions Trial number 255/29 of 1998-04 for commission of offenses under section 302, 315 and 201 of the Indian Penal Code on the accusation that on 11th February 1998 night at about 9 p.m. at village Tilidega, bracket Dumerguda, he committed murder of Kumudini Dungdung, bracket hereafter of the deceased, and her newly born female child. And threw the dead body of the deceased and her child into a well before the birth of the child with intention of preventing that child from being born alive. And after knowing certain offenses have been committed, he caused disappearance of evidence by tying the dead body of the deceased with stone and threw the same inside a well situated near Tumerguda with the intention of screening them himself from legal punishment. The London Trial Court, by judgment and order dated 26/2/2005, found the appellant guilty of the offences charged and sentenced him to undergo imprisonment for life under section 302 of the Indian Penal Code, rigorous imprisonment for 7 years, and to pay a fine of rupees 5,000 in default to undergo RI for a further period of 6 months under section 201 of the Indian Penal Code, RI for a period of 7 years under section 315 of the Indian Penal Code, and the substantive sentences of imprisonment were directed to run concurrently. As per the first information report lodged by Cecilia Dungdung, bracket PW3 of village Tolsara, bracket Patratuli, before the officer in charge of Kinjirikela police station on 24/2/1998, in short is that the appellant was working as a field servant in the house of the co-villager of the informant, namely Jacquias Dungdung. And was staying in the house of Jacquias Dungdung. During his stay there, the appellant kept illicit relationship with the deceased, for which the deceased got pregnant for 7 to 8 months. When the family members of the deceased came to know about the pregnancy of the deceased, a caste meeting was held on 8 to 1998. And in that meeting, a decision was taken that both the appellant and the deceased shall reside together as husband and wife, and a Foislanama was executed. After the decision was taken, both the appellant and the deceased stayed together in the house of the informant for 2 to 3 days. On 11 to 1998, at about 11 a.m., the appellant, along with the wife, along with the deceased, boarded a bus from Talsaraf gate to proceed towards Kinjirikela. While leaving her house, the deceased carried some saris, saya, rice, and other articles with her. The appellant gave them company till the bus stand. At Talsaraf gate. It is further stated in the first information report that on 24 to 1998, in the morning hours, the informant, along with her daughter-in-law, went to Kinjirkela, Rajapada, to see the well-being of the deceased. And while she was in front of the house of one Robert Topo of Rajapada,
Girjapada.
Girjapada?
Yes.
আচ্ছা এটা রাজিয়াপাড়া নয়, গির্জাপাড়া করে। Comma, she was informed that the dead bodies of a woman and a baby was floating inside a well which was situated in the land of one Uddhav Dandasena of village Dumer Gudapada. On suspicion, the informant proceeded towards the well, and the dead body of the woman was brought out of the well with the assistance of people of the locality, and the informant identified that woman to be the deceased. And she further found that stones were tied around the neck and buttock of the deceased, and the face and other body parts have been swollen, swollen, and a baby was a dead body of a child was also found floating, which was taken out of the well. The informant suspected that after bringing the deceased from her village on 11/2/1998, the appellant killed the deceased, so also her child, tied the stones, and threw the dead body of the deceased inside the well. PW3 lost the oral report before PW14 Purnachandra Maharana, the inspector in charge of Kinjirkela police station, which was reduced to writing, and the same was treated as the first information report. And Kinjirkela PS case number 8 dated 24/2/1998 was registered under section 302/201 of the Indian Penal Code against the appellant. PW14 himself took up investigation of the case. He examined the informant, bracket PW3, and one Muni Shoren, who had accompanied the informant to the police station. PW14 received information at 2:30 p.m. and he visited the spot at 3:30 p.m., which was the cultivable land of one Uddhava Dandasana in the village Dildega, Dumeruguda. PW14 found a well in the land, and the dead body of the deceased, so also a baby, was found floating in the well, and big stones were tied to the body of the deceased. And at a distance from the well, broken bangles were lying. Stop. Accordingly, PW14 prepared the spot map, He seized the broken bangles as per seizure list Exhibit 6, guarded the spot with the assistance of the constable. The dead body was brought out of the well during the night on 24 to 1998, and on 25 to 1998 at 6:30 a.m. PW 14 held inquest over the dead bodies and prepared inquest reports Exhibit 3 and Exhibit 4. He also seized granite stone boulders which were tied to the body of the deceased as per seizure list Exhibit 7. He examined some more witnesses and sent the dead bodies for post-mortem examination to District Headquarters Hospital, Sundargarh. Though search was made to arrest the accused, but it was found that the appellant had absconded. The wearing apparels of the deceased were produced before PW 14 by the constable who had escorted the dead body, which were seized as per seizure list Exhibit 8. Sample water from the well was collected and it was sent for chemical examination to FMT department, Medical College of Burla. He received the postmortem reports. So also the report regarding the sample water collected from the well. That the case was not due to drowning. Getting reliable information that the appellant was staying in Mumbai, the IO bracket PW 14 proceeded to Mumbai and the appellant was arrested on 8/8/1998. He was forwarded to the court at Mumbai and a prayer was made for issuing a transit warrant to bring the appellant from Mumbai. The IO came to know that the appellant was working in a hotel by giving a fake name. After the arrest, while in police custody, on 12/8/1998, the appellant confessed his guilt and further stated that he had thrown the bag containing the sari, sweater, saya, and blouse of the deceased together with stone into the well. And accordingly, he led the police party and other witnesses to the well from where the wearing apparels were recovered and a seizure list by Exhibit 5 was prepared. On 21/8/1998, PW14 handed over charge of investigation to his successor, Loknath Githi, who received the chemical analysis report and on completion of investigation submitted charge sheet against the appellant on 8/10/1998. Under section 302(201) of the Indian Penal Code. Next para. After submission of charge sheet, the case was committed to the Court of Session after complying due procedure, where the London Trial Court framed charges as aforesaid. Since the appellant pleaded not guilty and claimed to be tried, the sessions trial procedure was resorted to establish his guilt. In order to prove its case, the prosecution examined 14 witnesses. Name them and give it. The prosecution exhibited 20 documents, mention it. The prosecution proved 8 material objects, give it. The defense plea of the appellant is one of denial, and though he stated that he was working in a hotel and in a beer shop at Mumbai, but he had not given a fake name. He also denied that any articles were recovered at his instance. The London Trial Court summed up the circumstances appearing on record against the petitioner as follows. Quote from paragraph number 10. After analyzing the oral as well as documentary evidence on record, the London Trial Court came to hold that the prosecution, by adducing clear and cogent evidence, has conclusively proved that the appellant had illicit relationship with the deceased, and the deceased became pregnant through the appellant, and that a meeting was convened in the village of the deceased, where the appellant agreed to accept the deceased as his wife, and then they stayed in the house of the deceased for 3 days, and thereafter both the appellant and the deceased left together by a bus, and that the prosecution has established the facts consistent with prior relationship and last seen theories. The London Trial Court further held that the deceased and the appellant were last seen together on 11/2/1998. And the dead body of the deceased was recovered from a well and that the postmortem report exhibit 9 indicates that it was conducted on 27/2/1998 and time since death was about 12 to 14 days of PM examination. And therefore, these circumstances give rise to a presumption that death had occurred sometimes after the departure of the deceased with the accused, with the appellant. The London Trial Court further held that by adducing clear and cogent evidence, the prosecution has proved that soon after the occurrence, the appellant absconded from his ordinary place of residence and stayed at Mumbai with a fake identity. And this conduct of the appellant is indicative of the fact that he had a guilty mind and had absconded with the obvious intention of screening himself from legal punishment. It is further held by the London Trial Court that seizure of wearing apparels of the deceased, which were recovered at the instance of the appellant, further strengthens the case of the prosecution. The London Trial Court held that the appellant committed the murder of the deceased who was at an advanced stage of pregnancy with the sole intention to get rid of her and had thrown the dead body into the well after tying stones with the dead body with a view to cause disappearance of evidence of murder and to screen himself from legal punishment. He had fled away to Mumbai. It was further held that the prosecution has succeeded in proving its case beyond all reasonable doubt, and accordingly, the appellant was held guilty under section 302, 315, and 201 of the Indian Penal Code. Mr. S.K.SAHOO, Learned Counsel, appearing for the appellant, argued that there is no direct evidence in this case. The case is based on circumstantial evidence. And the circumstances are not established with clinching evidence. And they do not form a complete chain so as to come to a irresistible finding that it is the appellant and appellant alone who has committed the crime. It is argued that the FIR is an antedated one, and there is no evidence that after the departure from the village of the deceased, she was staying in the company with the appellant. And the last seen theory, which has been advanced by the prosecution, is not acceptable. It is further argued that the wearing apparels stated to have been seized at the instance of the appellant were not identified either by the mother bracket PW3 or by the brother bracket PW4 of the deceased. The Land Council submits that in view of the missing chain in the a missing link in the chain of circumstances, it would not be safe to convict the appellant under the offences charged, and therefore it's a fit case where benefit of doubt should be extended in favor of the appellant. Mr. Tripathi, led an additional standing counsel, on the other hand, supported the impugned judgment and argued that not only the Lennon trial court has chalked out the circumstances appearing against the appellant in paragraph 10 of the impugned judgment, but has also discussed the evidence on record with respect to each of the circumstances and found that the circumstances have been clearly established by the prosecution and that they do form a complete chain which points towards the guilt of the accused, and therefore the appeal should be dismissed. Coming to the first circumstance regarding illicit love affair between the appellant and the deceased, and that the deceased became pregnant through the appellant, and the circumstance number 2, that the appellant admitted his relationship with the deceased and agreed to keep her as his wife, has been stated to by a number of witnesses who were not only the family members of the deceased but also the co-villagers of the deceased, and they have stated that after it was known that the deceased is pregnant, a meeting was convened in the village, and in that meeting, in the presence of gentlemen, and also in the presence of the appellant and the deceased, the appellant admitted to be the father of the child which was carried by the deceased in her home. And at the first instance, a fine of rupees 10,000 was imposed on the appellant to be given to the deceased. But when the appellant expressed his inability to pay the said sum, it was decided that the appellant should marry the deceased, to which proposal the appellant agreed, and a document was prepared in that respect. The document has been marked as exhibit, the Panch Faisala document has been marked as exhibit 1, which has been seized by the IO under seizure list Exhibit 2. The mother bracketary PW3 and the brother bracketary PW4 have also stated in that respect. Nothing has been brought out in the cross-examination by the defense to discard this evidence. Therefore, the Lennon trial court was justified in holding that the circumstance A and B have been proved against the appellant. Coming to the one and two, Roman 1 and 2. Coming to the third circumstance, that the appellant stayed in the house of the deceased for few days, and thereafter the deceased left her house with the appellant together with her belongings. We find that there are some discrepancies in the evidence relating to the staying together of the appellant and the deceased for few days in the house of the deceased after the decision was taken in the meeting. No doubt in the first information report, it has been stated by PW3 that after Faisla was made in the village meeting, the appellant and the deceased stayed together in her house for 2 to 3 days. But PW3 has stated in her evidence that after the meeting, the deceased stayed with her and the appellant went to the house of Jacarias. PW4, the brother of the deceased has also stated that after meeting, the deceased resided in her house and the appellant resided in the house of Jacarias. However, so far as the circumstance that the deceased left her house with the appellant together with her belongings, the evidence of PW3 and PW4 are very much relevant. PW3 has stated that after 3 days of the meeting, both the appellant and the deceased proceeded to the village of the appellant, that is Kinjrikela. And on that day, she went to see them off at Talsara gate, where they boarded a bus. The PW3 has stated that the distance between her house and Talsara would be half a kilometer, and she went to see them off alone. She further stated that on being requested by the deceased, she had accompanied her to Talsara Fatak, and on that day, the deceased did not No. And that they boarded a bus and and that she told about the departure of the deceased with the appellant to her sons. PW4 has also stated that 3 days after the meeting, both the appellant and the deceased left their village, and PW3 went to see them off. And after returning from bus stand, PW3 revealed before him that she saw them off. Therefore, so far as the circumstance number 3 is concerned, though the evidence relating to the appellant staying with the deceased in her house is not established by the prosecution, but the prosecution has successfully established that the appellant and the deceased left together from uh, uh, at and they boarded a bus at Talsara Fatak. The main circumstance that is missing in this case is that after the departure, the appellant and the deceased stayed together. Nobody has seen the appellant and the deceased staying together under one roof after they left the village of the deceased on 11 to 1998. The dead body was recovered on 24 to 1998, and there was a gap in between. There was a gap of 13 days in between. Neither the mother bracketary PW3 nor the brother bracketary PW4 of the deceased have stated that after the deceased left the village by boarding a bus at Talsara Fatak, she made any communication with them and told that she was residing with the appellant under one roof. In the case of Muhammad Azad alias Samin versus State of West Bengal, reported in 2008 15 SCC 449, State through CBI versus Mahinder Singh Dhaiya, reported in 2011 3 SCC 109, and Sheikh Yusuf versus State of West Bengal, reported in JT 2011 6 SC 640. It is held that the last seen theory comes into play where the time gap between the point of time when the accused and the deceased were last seen alive and when the deceased was found dead is so small that the possibility of any person other than the accused being the author of the crime becomes impossible. In this case, since there is no evidence of the deceased and the appellant staying together under one roof after they they boarded a bus at Talsara Fatak on 11th to 1998. We are of the view that a vital link in the chain of the circumstance is missing, which has been overlooked by the London Trial Court. Coming to the fourth circumstance which has been enumerated in the impugned judgment by the London Trial Court, we find that in the first information report, which is stated to have been lodged at 2:30 p.m. on 24/2/1998, it is mentioned that while the informant was coming to see the well-being of the deceased on 24/2/1998 in the morning hours, in front of the house of Robert Topo of Girjapada, he received the information that the dead bodies of a woman and a child were floating in a well, and accordingly, on suspicion, he went to that place, and with the help of the owner of the landlord, so also other persons, the dead bodies were brought out of the well, and the informant could identify the dead body of woman to be that of the deceased. Therefore, from the first information report, it is apparent that by the time the FIR was lodged, the dead bodies were already brought out of the well. Most peculiarly, the investigating officer bracket PW14 has stated that after the registration of the FIR, he proceeded to the spot and found that the well was full of water, and the dead bodies were found floating in the well. He further stated that he took steps for guarding the spot, and on the next day, that is on 25/2/1998 at 6:30 a.m., he held inquest over the dead bodies, which were brought out of the well during the previous night. Therefore, the evidence of the investigating officer runs completely contrary to the narration made in the first information report regarding the recoveries of the dead body from inside the well. Whereas the IO has stated that the dead bodies were brought out of the well on 24/2/1998 in the night. In the first information report, it is mentioned that by the time of lodging the first information report, that is at 2:30 p.m., the dead bodies had already been brought out of the well. If the investigating officer's statement is accepted that the dead bodies were brought out of the well in the night of 24/2/1998, then it creates suspicion that perhaps the FIR, which contains the averments regarding the recoveries of the dead body from out of the well, was lost after such recovery, and therefore the FIR is an antedated one. The appellant, the next circumstance discussed by the London trial court was that the appellant was found missing from the village, and he was arrested from Mumbai, where he was working for some time with a fake name. The appellant has not disputed about working in Mumbai, but he has not admitted that he had used any fake name before at Mumbai. Therefore, stop. The next circumstance which has been discussed by the London trial court is that the wearing apparels of the deceased were recovered at the instance of the appellant. The dead bodies were recovered on 24/2/1998. The appellant was arrested on 8/8/1998, and on 12/8/1998, on the information of the appellant, some wearing apparels were seized from inside the whale. But neither the wearing apparels were shown to the mother (PW3) nor to the brother (PW4) of the deceased to identify the same. No other person has identified the deceased and the wearing apparels to be that of the deceased who has got acquaintance with the same. Therefore, even though the circumstance has been established to the extent that some wearing apparels were seized from the whale at the instance of the appellant, but it has not been established that those were of the deceased. So far as the last circumstance is concerned, the doctor, that is PW 11, conducted post-mortem examination over the dead body, and he noticed as follows, and he has given the opinion that the death is homicidal one, of the deceased is homicidal one, and the London counsel for the appellant has not disputed the same. So far as the death of the child is concerned, the doctor has opined that the death of the female child might have occurred with the death of their mother and might have been expelled out of the uterus due to the decomposition. And the ossification test indicated that it was a full-term baby of almost 8 to 9 months. The postmortem report of the deceased has been marked as Exhibit 9, and that of the baby has been marked as Exhibit 10. In view of the foregoing discussions, though we are of the view that the prosecution has successfully established that the appellant had illicit relationship with the deceased and the deceased became pregnant on account of such relationship, and a written document was executed in a meeting in which the appellant agreed to accept the deceased as his wife. But there is no evidence on record that after such decision was taken, the appellant and the deceased stayed together in the house of the deceased for few days. The evidence no doubt established that the appellant and the deceased lived together in a bus, but and the dead bodies of the deceased and a baby were recovered from a well after 13 days of such departure, and the appellant was arrested from Mumbai, and at his instance, at the instance of the appellant, some wearing apparels were seized from a well, and that the deceased and her baby, the deceased met with a homicidal death. But since there is a time gap between the last scene of the appellant and the deceased together at the bus stand by PW3, and there is no material that after such departure they were staying together under one roof, and in between the time gap between the detection of the last scene and the detection of the dead bodies, we are of the view that the vital link in the chain of the circumstance is missing. And law is well settled as held in the case of Sarad Brichand Sarda, where the Panchashil to prove the chain of circumstances in a case of circumstantial evidence has been discussed. We are of the view that the circumstances which have been established by the prosecution do not form a complete chain so as to unerringly point towards the guilt of the appellant. And since the possibility of the deceased coming in contact with a third person and that third person committing the crime cannot be ruled out, we are of the view that it would be very risky to accept the prosecution evidence to hold the appellant guilty of the offences charged. Accordingly, the impugned judgment and order of conviction of the appellant is hereby set aside. The appellant is acquitted of the charges under section 302, 315, 201 of the Indian Penal Code. देखिए record टा देखिए से bail थिला कि विचार थिला.
He was on bail matter 14/3/2014.
As it appears from the record that the appellant was केबे
14/3/2014.
Was directed to be released on bail, the bail bond and the surety bond. तापर अब arrest ही नहीं तो
No, my lord.
stand cancelled. Put a note of appreciation on Mr. Sahu and Mr. Tripathi.
Maybe pardon to mention, madam, in an appeal, conviction is 10 years. Out of 10 years, the appellant has remained in custody 5 years, 7 months. Now, another 2 restoration.
Out of 20 years to 10 years and already completed with.
Application to conviction, my lord, I have filed a bail application. Application to conviction, my lord, I have.
My lord, in this revision, I have challenged the rejection of discharge petition, allegation of 139% and 5 years charge sheet file only 38%. And charge is case is posted on 17/1. I had already also made mention in last week. Your Lordship was pleased to allow my memo next week. Since there is no specific date, matter is not coming. Date.
It's a revision against 457 order. For admission stage, it was posted and hearing was partly done. Thereafter, from 10th October 2023, it is not been coming on.
Revision.
The criminal revision 318 of 2020.
Criminal revision is not assigned to me, I think.
My revision is a vigilance case, my lord. I had also mentioned vigilance.
No, revision petition is not, that is only arising out of CBI cases.
CBI revision.
CBI and vigilance.
Then
It's not coming out.
My case is also vigilance case.
Jail criminal of 2020. This was after filing of this case, my lord, this was posting for hearing. Bail application, my lord, pending.
Yes.
Lordship, verification of document, Lordship. Interim bail, your Lordship has allowed the petitioners. Only
What?
verification documents, Lordship. West Bengal, Lordship.
Petition?
Of documents and address verification.
Yeah.
Lordship to appeal bail.
Appeal bail.
Lordship.
Yeah.
Appeal for bail.
Yeah.
Bail matter, my lord. Tie-up matter, my lord. My lord, two bail petition of same person. It was directed to be listed on 8th, but could not have been listed.
Lordship, I have filed for arising on bail matter, Lordship. Bail matter, Lordship, for constitutional bail.
Pardon to mention, my lord, it's a criminal appeal. Your lordship, it was listed initially, but then it got delisted.
Okay, give it.
May I pardon your lordship? A criminal appeal of 2001 matter when was listing for hearing, nobody was appearing from the appellant side. NBW was issued and NBW was issued by this honorable court and voluntarily the appellant was surrendered before the court below. He is in custody. I am filing a miscase and I am entering for the on behalf of the appellant. Kindly be listed, my lord.
For bail.
My lord.
Okay, give it.
Fresh application.
Fresh admission. Criminal appeal.
Supplement list item 6 and 7, my lord. Fresh admission matter notice to go, my lord. I will solve the strategy.
But which is the matter?
6 and 7, my lord.
SCST appeal. The State Council, Mr. Tripathi. This item number 6 and 7, these are two SCST criminal appeals. So he is serving extra copy. You take the instruction. Let me know. 6 and 7. Since the one of the offense is under section 7.
No. Serial number 6 and 7.
Serial number 6 and 7. The number uji 5 and 6, right? Extra copy, it will be sent to so and so IAC. So CD and criminal antecedent confirmation letter regarding service of notice. So it is to come 1 week after rotated date. Yes.
Obliged.
My lord, item 5 minutes.
Item number 13. He was granted bail, entering bail for a period of 3 months from the date of release. And he was released on 30 October 2023. So 3 months will complete on 30 January. So accordingly, will surrender certificate will be submitted.
Alright, the Learned Council, item number 13, appearing for the appellant submitted that though this matter has been listed for non-filing of the surrender certificate, but the appellant was released on bail in the end,
30 October 2020.
30th of October 2023, and therefore the 3 months bail, interim bail period has not expired. In view of such submission, put up this matter in the second week of February 2024, surrender certificate to be filed. Yes, next.
Item 19, my lord. Interim bail was the last occasion in 12/12/2023. No report has been received.
No, you wait till that matter reaches there because I am taking up the election petition.
My lord, item 5, my lords. I am on VC mode.
Mr. You was on
My
bail
lord, senior was on not present, so it was urgent.
yesterday. You have received the copy.
Yes.
Okay.
I'll file my appearance memo by the end of March.
All right. Admit you are on bail. Bail granted. Stay realization of fine. You will file the appearance memo by end of March 2024. Free copy of the order be handed over to them. Yes.
My lord, item 5, my lords.
Yes.
SC matter, my lord, notice to go.
Okay. Here also, Mr. Item number 5, serial number 5 is a phrase matter. So you will hand over the copy by tomorrow.
Right now, I am handing over, my lord.
Extra copy be handed over. Baki usual order like item number 6 and 7, CD, CA and confirmation letter to be obtained. All right.
Oblige.
Yes.
May I please?
Supplementary list, item number 45.
I will address your lordship about paragraph 7D, 7E and 7F. 7D is available to your lordship at page 13 and 14 of the election petition.
Yes.
I have summarized it to 5 items, A, B, C, D, E. Respondent in the affidavit, though has mentioned about the account number so and so, joint account in the Federal Bank Limited, Bajrakobati Road, Kotak, but has not disclosed the name and other details of the joint account holder of the above said bank account, and has not indicated about the extent of ownership in the said bank account. The respondent in the affidavit, though has mentioned about the account number so and so joint account SBI main branch Badambadi Kotak, but has not disclosed the name and other details of the joint account holder of the above said bank account, and has not indicated about the extent of ownership in the said bank account. C. Column 7 III. The respondent has declared about the investment made in shares of different companies, but has not declared the book value of the shares as per the books of the company. Seটা actually 7II न होइकिरी kindly note 7A triple I.
Wrong reading.
Wrong reading. Okay. Then D, in column 7IV, it is 7AI. সেটা টিকে লিখে দিন 7AIV. রিডিংটা টিকে মিস্টেক রয়ে যাচ্ছে।
এটা হলো page 13.
আজ্ঞা। The respondent is required to declare the details of
7 Roman 3 জায়গায় কেতে হবো?
7A capital A Roman 3. ସେଇଟା ବି ସେମିତି 7 capital A Roman IV. Then E, respondent has given loans to 6 companies, but the details of the same have not been given. The respondent has dealt with these paragraph 7D under paragraph 23D at page 56 to 65. The above allegations made by the election petitioner in his election petition are completely based on surmises, out and out false, fabricated, concocted, and hence stoutly denied. It is only submitted by the sole respondent that all the above allegations pleadings are verified material facts and the same do not disclose complete cause of action. Inasmuch as those allegations are wholly unnecessary, frivolous, vexatious, scandalous, and tend to prejudice the fair trial of the case, and as such, the pleadings made under paragraph 7D of the election are liable to be struck down, being hit by Order 6, Rule 16 of the CPC. Then, A. Allegations, pleadings as enumerated under A above, mu A to A karichi are bereft of the following material facts. It has not been pleaded, disclosed in the election petition as to whether the candidate is required under the law to give the details of the joint account holder or not. It is only submitted by the sole respondent that in fact there is no such legal provision for disclosure of the details of the joint account holder in affidavit 26. 2.
ଏଟାକୁ ଟିକେ ପଳେଇ ଆସୁନାହାନ୍ତି ତାପରେ ପ୍ରୋସିଡ୍ କରିବା ସେ ଯୋଉ ଫର୍ମଟାରେ ଯୋଉଟା
ଆଜ୍ଞା HBR
ସେଟା
exhibit 38.
exhibit
38 by 4.
exhibit 38 ଟା ଭଲ।
Page 363 ରୁ ଆରମ୍ଭ ହେଇଛି।
ହଁ କୋଉ ପେଜରେ ଅଛି?
ସେଟା ଅଛି ପେଜ 367 ରେ paragraph 7 ଆରମ୍ଭ।
367
ଆଜ୍ଞା ସେଠି କଲମ 7 ଦେଖନ୍ତୁ ତା ତଳେ ଇନଷ୍ଟ୍ରକ୍ସନ୍ସ ଅଛି।
କଲମ 7 ହଁ
ନୋଟ ଦେଖନ୍ତୁ details of movable assets. Note 1, assets in joint name indicating the extent of joint ownership will also have to be given.
ହଁ ଏଇଟା ତ ଅଛି।
Not the name of the joint account holder. ସେ ଆକାଉଣ୍ଟରେ ମୋର କେତେ ଅଛି ସେଟା ମୁଁ ଜଣେଇବି।
Assets in joint name indicating the extent of
joint
ownership will have to be given.
Not the name of the joint account holder. ତାଙ୍କର ଆଲିଗେସନ ହଉଛି ଜଏଣ୍ଟ ଆକାଉଣ୍ଟ ହୋଲ୍ଡର ଙ୍କ ନାଁ ଦେଇନା।
ଆଉ ଥରେ ଦେଖିବା ସେଟା ସେ ପ୍ଲେଟିଂ ଟା ଆଉ ଥରେ ଦେଖିବା।
ଆଜ୍ଞା
ସେଟା 13 ନମ୍ବର ପେଜରେ ଅଛି।
ତାଙ୍କର ପ୍ଲିଡିଂ ହେଲା he has not disclosed the
name and
other details of the joint account of the acha tale what do you mean to say
Next line also
and has not indicated the extent of acha even dita ago but she kouchanti extent of ownership is required to be shown but the name and other details of the suppose gote particular account re it's a joint account holder. You mean to say that if you show that my extent of ownership is 40% in this particular account, then that would be sufficient. It's not necessary that who is the other account holder and
in the instant case, my lord, the bank account stands in the name of the respondent as well as his spouse. With the operational instruction either or survivor. I mean, need to sit pleading that.
अच्छा जोटा ऐसे जोटा बाहर करथले से जो बहिरु 38 टा बाहर करले assets in the joint name indicating the extent of joint ownership will have to be given. अच्छा okay all right carry forward. Mr. Mishra please clarify फिर पड़े से जोटा pleading टा जोटा देखो हाँ
then the respondent in the affidavit though has mentioned about the account number so and so तांगर allegation ता हमर आंसर टा होची 23D रे While making such allegation, the election petitioner has not disclosed, pleaded the column number of the affidavit under which the respondent has furnished such information. ସେଟା ଆମର ରିପ୍ଲାଇରେ ଆମେ କହୁଛୁ। Third ହେଲା, the election petitioner has suppressed the material fact that under column 7A the candidate is required to furnish information about details of deposits in bank accounts, FDRs, term deposit, and all other types of deposits, including saving account. Deposit with financial institutions, non-banking financial companies, and the cooperative societies, and the amount in each such deposit. Then though the respondent has disclosed the amount available in the said amount, the same has not been disclosed pleaded by the election petitioner. The election petitioner has suppressed the very important material fact that the said bank account is a joint account along with the spouse of the respondent, namely Firdausia Bano, and said bank account is opened with the operational instruction either or survival. There is no pleading to the effect that on account of such non-mentioning of the extent of ownership in the said bank account, the electors have been misled and the result of the election in so far as it concerns the returned candidate has been materially affected. Then B, allegations pleading as enumerated under B above is bereft of the following material facts. The averments made with respect to the name of the branch, that is SBI main branch Badambadi, is wrong. Respondent is affidavit has mentioned the said bank account SBI main branch Chandin Chowk, collectorate pakhre do account. Main branch ta collectorate pakhre Badambadi no. So this is a wrong assertion or pleading in the election petition. It has not been disclosed in the election petition as to whether the candidate is required under law to give the details of the joint account holder or not. It is only submitted by the respondent that in fact there is no such legal provision for disclosure of the details of the joint account holder in affidavit form 26. While making such allegations, the election petitioner has not disclosed, pleaded the column number of the affidavit under which the respondent has furnished such information. Then IV, the election petitioner has suppressed the material fact that under column 7AII, the candidate is required to furnish information about the details of deposit in bank accounts, FDR, term deposits, and all other types of deposits, including savings account deposits with financial institutions, non-banking financial companies, and cooperative societies, and the amount in each such deposit. B, though the respondent has disclosed the amount available in the said account, the same has not been disclosed pleaded by the election petitioner. VI, the election petitioner has suppressed the very important material fact that the said bank account is a joint account along with the spouse of the respondent, namely Firdausia Banu, and the said bank account is opened with the operational instruction either or survival. VII, there is no pleading to the effect that on account of such non-mentioning of the extent of ownership in the said bank account, the electors have been misled and the result of the election insofar as it concerns the returned candidate has been materially affected. Then C. The allegations pleading as enumerated under C above is bereft of the following material facts. The election petitioner has suppressed the material fact that under column 7 capital A III, the candidate is required to furnish information about details of investment in bank, debentures, shares, and unit in companies, mutual funds, and others, and the amount. II, though the respondent has mentioned the name of the companies wherein he has made investments, the election petitioner has not disclosed the same in his election petition. III. Though the respondent has mentioned the amount in rupees in respective companies, the election petitioner has not disclosed the same in his election petition. IV. There is no pleading of the material facts to the effect that under column 7A note 3, the candidate is instructed to furnish information about the value of bonds, shares, debentures as per the current market value in stock exchange in respect of listed companies and as per the book in case of non-listed companies should be given. V. There is no pleading to the effect that the companies mentioned in the 7A III, wherein the respondent has made investment, are not listed companies but not non-listed companies. VI. There is no pleading to the effect that the amount shown against the respective company is not the book value of the shares. VII. There is no pleading about the numbers of shares owned by the respondent in different companies. VIII. There is no pleading to the effect that on account of such non-mentioning of the book value of the shares as per the books of the companies, the electors have been misled and the result of the election in so far as it concerns the written candidate has been materially affected. D. The allegation pleading as enumerated under D above is bereft of the following material facts. Though the respondent in his affidavit in form 26 under column 7A IV has disclosed the names of the insurance companies, policy numbers, policy date, and the surrender value of such policies made in his name and the name of his spouse, such material information facts have not been pleaded in the election petition. II. There is no pleading to the effect that on account of such non-mentioning of the details of the investments made respondents and his spouse insurance policies, the electors have been misled and the result of the election in so far as it concerns the returned candidate has been materially affected. E. The allegations pleading as enumerated under E above is bereft of the following material facts. I. There is no pleading showing that under which column the affidavit of respondent has furnished information about loans given in 6 companies. II. Though the respondent under column 7AB has mentioned the name of the company's entity firm along with the amount of the loans to the respective company's entity firm, the same has not been pleaded disclosed in the election petition. II. There is no pleading to the effect that on account of such allegation, the result of the election in so far as it concerns the returned candidate has been materially affected. On the respective pleadings of the parties, your lordship framed issue number 22, whether the respondent has disclosed the name and other details of the joint account holder.
Yes. Issue number note.
Issue number 22, 23, 24, 25, 26, 27, 28, 30 and 33. ମୁଁ ଗୋଟି ଗୋଟି କରି ଆଉ
22 ଟୁ କେତେ ଯାଏ କହୁଛନ୍ତି? 22 ଟୁ
22 28
28 and
ତାପରେ 30 ଆଉ 33
30 ଆଉ 33
ଆଜ୍ଞା ଆଉ କଣ
ନାଇଁ ନାଇଁ ସେଟା ମାନେ ମୁଁ ଖାଲି just please answer me. Suppose what you they ସେମାନେ ଖାଲି କହିଛନ୍ତି ଯେ for example, let us say come to that election petition.
A, B, C.
We are concerned with now D upon press କରୁଛନ୍ତି ତ page number 13 ରେ
7D
7D ର page 13 ଟି ଟିକେ ଦେଖନ୍ତୁ
ଆଜ୍ଞା
ଏଇ ଯୋଉ last year ଲେଖୁଛନ୍ତି further 1 2 3 4 5 6 7 lines from the bottom of that page. Further in column number 7-4 এটা ଆପଣ କହୁଛନ୍ତି 7A4 ହବ
ଆଜ୍ଞା
the respondent is required to declare the details of the investment in NSS, postal savings, insurance policies, or in any financial investment in the post office as per the that
affidavit ଅଛି
kintu se kହୁଛନ୍ତି but the respondent has not given the details of investment made is in his and his spouse insurance policies ei aberment ରହିଲା तामाने से खाली स्पेसिफिक କରୁଛନ୍ତି insurance companies ଉପରେ so that means they have no grievance so far as NSS, postal savings etc.
any other
हाँ
investment
हाँ ସେମାନେ କେବଳ insurance policies କୁ what you say that ସିଏ ଖାଲି ଗୋଟେ ମାନେ ଯୋଉ assertion ନେଇଛନ୍ତି ହଁ
କିନ୍ତୁ ତାର ଡିଟେଲ୍ସ କିଛି ଦେଲେ ନାହିଁ କୋଉ ଇନ୍ସୁରାନ୍ସ ରେ ପଲିସିରେ ଆମେ ଦେଇନାହୁଁ ସେ ଖାଲି ଏତିକି କରିଦେଲେ ହବନି ସେ କହିବାକୁ ହବ ଯେ କୋଉ ଗୋଟାକ ଅଛି ମୁଁ ଦେଇନି
ହଁ ମନେକର ନ୍ୟୁ ଇଣ୍ଡିଆ ଇନ୍ସୁରାନ୍ସ ସେଥିରେ ତାଙ୍କର ଗୋଟେ ଏଇ ପ୍ରକାର ଇଏ ରହିଛି ଏମିତି ଗୋଟେ
ଏଇଟାକୁ ସେ ଓମିଟ୍ କରିଦେଇଛନ୍ତି
LIC ର ଗୋଟେ ଏଇ ଟାଇପ ର LIC ଇଏ କରିଛନ୍ତି ଯୋଉଟା କି ସେ ଏଇ ଯୋଉ ଜିନିଷ ଗୁଡାକ ଆପଣ କହୁଛନ୍ତି
must be correct and specific
right so that aberrament should have been there okay they now they have come up with the in detail in the evidence affidavit or what ନା ସେଥିରେ ବି କହିନାହାନ୍ତି
ଏଭିଡେନ୍ସ ରେ ଆମେ ଯିବୁନି କି
ନାଇଁ ନାଇଁ ମୁଁ କହୁଛି ସେମାନଙ୍କର ଇଲେକ୍ସନ ପିଟିସନର ଯେତେବେଳେ ସେଥିରେ ବି କହି ସେଇ ଟାଇପ ର ଭେକ୍ କରି ଛାଡିଛନ୍ତି ଓକେ on the other hand your averments is that we have
furnished
okay and
ଏଇ ସମ୍ପର୍କରେ ଯୋଉ ଡକୁମେଣ୍ଟାରୀ ଏଭିଡେନ୍ସ ଅଛି ବୋଥ ତାଙ୍କ ତରଫରୁ ଆମ ତରଫରୁ ସେଗୁଡାକ ବି ମୁଁ ଡାକି ଦଉଛି ଏକ୍ଜିବିଟ୍ ED ଦେଇନାହାନ୍ତି ଆଗ ଏଇଟା କହିଲେ The election petitioner 7D of the election petition as well as the above 9 issues, the election petitioner has miserably failed to adduce any documentary evidence. କୌଣସି ଦେଇନାହାନ୍ତି ଏଟା ମୁଁ specifically allege କରିଛି. On the other hand, the following documents have been marked as exhibits on behalf of the respondent. ଆମେ ଏଗୁଡାକ ଦେଇଛୁ.
ହଁ ଯୋଉ ପଲିସି ଗୁଡାକ ଆପଣଙ୍କ ନାଁରେ ଅଛି ସେଗୁଡାକ ହଁ
ବ୍ୟାଙ୍କ ଉପରେ
ବ୍ୟାଙ୍କ ଉପରେ ହଁ
ଏକ୍ଜିବିଟ୍ ED ମାଇ ଲର୍ଡ
ଲେକ୍ଚର
ED ହଉଛି ପାସବୁକ୍ ଟା ଫେଡରାଲ ବ୍ୟାଙ୍କ ର
ଖାଲି ମତେ କୁହନ୍ତୁ ସେଟା
ଦେନ୍ ED by 1 ସେକେଣ୍ଡ ଟା ହଁ ଏକ୍ଜିବିଟ୍ ଡବଲ E and exhibit double E by 1
ଏଇ ଚାରିଟା ଆପଣଙ୍କର
ଆମେ
ଓକେ
এটা ব্যাংক পাসবুক গুলো
so Mr. Mishra what you want to show that they should have given taken a specific averment that a insurance
and
company
specific document documentary evidence
ଏଇ insurance company ବା ଏଇ ବ୍ୟାଙ୍କ ରେ ତାଙ୍କର ଏତିକି ଟଙ୍କା ରହିଛି ଯୋଉଟା କି ସେ ଦେଖେଇବା କଥା ଯୋଉଟାକୁ ସେ ଦେଖେଇ ନାହାନ୍ତି ତେଣୁ ଇଟ୍ସ ଏ ସପରେସନ ଏ ଟାଇପ ର ନ ନେଇକି ଯୋଉ ଭେଗ ଆଭରମେଣ୍ଟ ନେଇଛନ୍ତି ଯେ ସେଟା that would not be acceptable okay yes
ତାପରେ so far as the oral evidence is concerned PW1 ମୁଁ ଖାଲି ପାରାଗ୍ରାଫ ଗୁଡା ଦେଇ ଦଉଛି evidence on affidavit exhibit 36 PW1 paragraph 21
36 ଲେଖିଲି paragraph
21 page 16 and 17 ତାର ଦେହରେ ଯୋଉ ଦେଖିବେ ଇଟାଲିକ ପୋର୍ସନ ଯେତିକ ଆମେ ନୋଟ ରେ ଦବୁ those are beyond pleadings
okay italic portion beyond pleading okay
ଆଉ ସେଇଥିରେ ବି ଯୋଉ ଗୋଟାକୁ ମୁଁ ଏବେ କହିଲି ସେ ଯୋଉ ଲେଖିଛନ୍ତି କଲମ 7A small a is not correct 7 capital A small a
ନାଇଁ 7 ASML ଲେଖିଛନ୍ତି 7 small a, that is not correct. Correct column is 7 capital A.
Okay.
And then जो column 7 triple A जो ଲେଖିଛନ୍ତି that is not correct. Correct column ହଉଛି 7A triple I.
ତାପରେ paragraph 22 PW1 at page 17. Then paragraph 23
ନାଇଁ ଏଇଟା ସେ ଆର୍ଗୁମେଣ୍ଟ କରୁଛନ୍ତି they will when they will give the copy
ଆମେ note ଆପଣଙ୍କୁ ଦବୁ
argument call out to we cannot reply because my senior will get a chance to reply my argument. We will put
no, why are you not noting down? I am noting down. Why are you not noting?
It is a draft, not final.
ଓ ସେଇ ଯୋଉ ଇଏରେ
ନାଇଁ ନାଇଁ ମୁଁ ଯେତେବେଳେ ସାର୍ଙ୍କୁ କହୁଛି ସାର୍ ନୋଟ୍ କରୁଛନ୍ତି ଆପଣ ନୋଟ୍ କରିଦିଅନ୍ତୁ
କୋଉ ପୋର୍ସନ ଟା ଆପଣ ଇଟାଲିକ ଦେବେ ମୁଁ ଜାଣିପାରିବିନି
ସେଟା ନୋଟରେ ଦେବି
ନୋଟ ସେଇ ପ୍ରକାର
ସେ କହୁଛନ୍ତି ମାନେ ଆପଣ ସିନା ନୋଟ ରେ ଦେଇଦେବେ
ଆଜ୍ଞା
ସେ ତାପରେ ସିଏ ତ ଆପଣଙ୍କର ଅବଜେକ୍ସନ ମାନେ ଇଏ କରିବେ
ସେ ତାଙ୍କ ନୋଟରେ ଦେଇଦେବେ
ସେ ତାଙ୍କ ନୋଟ ରେ ଦେବେ but he say that you are getting one more chance to reply whereas they are not getting
ଆମେ ତ ଉଭୟ ଦବୁ ନା ରିଟନ୍ ନୋଟ ତେଣୁ ସେ ରିଟନ୍ ନୋଟ ରେ ଇଣ୍ଡିକେଟ କରିଦେବେ
now Mr. Kanungo they are not giving anything to me in writing I'm just whatever he is just noting I'm just noting down preparing a note in my house that's all but this detail he will be furnished later on to the
paragraph ଟା ମୁଁ କହୁଛି ତାରି ଧିରେ ଇଟାଲିକ ପୋର୍ସନ କୋଉଗୁଡାକ
ପେଜ ନମ୍ବର କହୁଛନ୍ତି paragraph ବି କହି ଦଉଛନ୍ତି
ଆପଣ ସେଇଥିରେ ଦେଖିଦେଲେ ଜାଣିପାରିବେ paragraph 23
ସେ କହୁଛନ୍ତି ଏଇ portion ଟା ହବ beyond pleading that also you have to see all right he will give it later on yes
paragraph 23 at page 18
just a minute
ତାପରେ କ୍ରସ୍ examination in chief
examination in chief
ଆଜ୍ଞା ଆଜ୍ଞା
evidence exhibit 36
examination in chief ରେ ତାଙ୍କର କିଛି ଏ ସମ୍ବନ୍ଧରେ ନାହିଁ ବୟାନ ତାପରେ କ୍ରସ୍ ଏକ୍ସାମିନେସନ ରେ paragraph 78
just
examination chief ରେ no statement
evidence affidavit ରହିଲା
ଏତିକି
no chief examination ରେ କିଛି ନାହିଁ
କ୍ରସ୍ ଏକ୍ସାମିନେସନ ରେ paragraph 78 page 33 ନାହିଁ paragraph 79 page 33
just a minute again please tell me cross examination
paragraph 78 page 33
ଯଦି କହିବେ ମୁଁ ପ୍ଲେସ୍ କରିଦେବି
ନାଇଁ ନାଇଁ କିଛି ଦରକାର ନାହିଁ ଆପଣ କୁହନ୍ତୁ ପ୍ରିଡିଂ ନାହିଁ ଯୋଉଟା କ୍ଲିୟର କରିଦେଲେ ଜଣା ପଡିଯିବ ଆଉ କଣ
paragraph 79 page 33 and 34
33 34
paragraph 80 page 34 and 35
34 35
ଆଜ୍ଞା paragraph 81 35 and 36 page
36
ଆଜ୍ଞା ତାପରେ paragraph 80
in this cross examination he has admitted that there is no pleading
ଆଜ୍ଞା paragraph 82 page 36 ଏତିକି
okay
then I will come to 7E 7E is available to your lordship at page 14
कितने
at page 14 of the election petition
7E
I have summarized it to 3 categories A, B, C. In column 7BII, the respondent has declared about the non-agricultural land in district Cuttack, Mauza, Patpur, Khata number 15D, plot number 114, 116, 112, 113. There is no Mauza known as Patpur in the district of Cuttack. Consistently, they have been saying that, and we have been answering to that. So the khata number and plot number described therein are all false declaration. ଆମେ ଖାତା ନମ୍ବର ଦେଇଛୁ, ପ୍ଲଟ ନମ୍ବର ଦେଇଛୁ, ମୌଜା ନାଁ ଦେଇଛୁ, ଖାଲି ଏରିଆ ଦେଇଛୁ।
ଲିଷ୍ଟ କଟକଟା ହବନି, ସେଟା
କଟକଟା ଖୋର୍ଦ୍ଧାଟା କଟକ
ଖୋର୍ଦ୍ଧାଟା କଟକ ହେଇଯାଇଛି।
ହଁ ଭାଇ,
ହଁ
ସିଏ କହୁଛନ୍ତି କଟକ ଜିଲ୍ଲାରେ ପାଟପୁର ମୌଜାଟି ନାହିଁ।
ହଁ ମାନେ
ଆମେ prove କରୁଛୁ ପାଟପୁରା
ହଁ
ମୌଜା
ମୌଜା
କହୁଛନ୍ତି,
ପାଟପୁରାଟା
ସେପଟେ।
ସେ କହୁଛନ୍ତି ମୌଜା ପାଟପୁରା ଖୋର୍ଦ୍ଧାରେ ଅଛି ପୁରା ଏଭିଡେନ୍ସ।
ନା
ଆଉ
ସେଟା ଭୁଲ କଲେ ସାର୍। ତାଙ୍କର ଆଲିଗେସନ ହଉଛି ପାଟପୁର ମୌଜାଟି କଟକ ଜିଲ୍ଲାରେ ମୂଳରୁ ନାହିଁ।
ହଁ
ଆମେ ପ୍ରୁଭ୍ କରିଛୁ ଡ୍ୟୁରିଂ ଏଭିଡେନ୍ସ କି ପାଟପୁରା ମୌଜାଟା ହଉଛି, ଆପଣ ଯଦି ଗୁଗୁଲ ମ୍ୟାପ କାଢିକି ଦେଖେଇଥିଲେ PW1 କୁ, ଜଷ୍ଟ ନଈ ସେପଟେ ହଉଛି ଚୁଚୁଳିଆ ପାଖରେ ପାଟପୁରା।
but that comes within I think
କଟକ ଡିଷ୍ଟ୍ରିକ୍ଟ,
huh
in କଟକ ଡିଷ୍ଟ୍ରିକ୍ଟ,
acha
in କଟକ ଡିଷ୍ଟ୍ରିକ୍ଟ।
non agricultural land and so and so they submit at present there is no mauja known as Patpur in Cuttack district.
ଆଜ୍ଞା
So also khata number so and so khata number goda kon କହିଛନ୍ତି false କହୁଛନ୍ତି।
ସବୁ ଠିକ ଅଛି।
ଠିକ ଅଛି।
ଖାତା ନମ୍ବର, ଏରିଆ, ପ୍ଲଟ ନମ୍ବର,
ଠିକ
ଏଗୁଡ଼ା ସବୁ ଠିକ। Date of purchase.
leave it there, leave that.
Then B, respondent has declared about the non-agricultural land in the name of his spouse in district Cuttack, Mauja Patpur, Cuttack, a khata number 16D1, plot number 111 by 1048. There is no Mauja known as Patpur in the district of Cuttack. ତାଙ୍କର କଣ୍ଟ୍ରୋଭର୍ସିଟା ହଉଛି ପାଟପୁର କି ପାଟପୁର। ହଁ, ଆମେ କହୁଛୁ ସେ ପାଟପୁର ଇଜ ମ୍ୟାଟେରିଆଲ। ପାଟପୁର ମୌଜା କଟକ ଡିଷ୍ଟ୍ରିକ୍ଟରେ ଅଛି ଏବଂ ନଈ ଆର ସେପଟେ ଅଛି।
ଓଡିଆରେ ଲେଖିଲେ ସମାନ,
ସମାନ,
ଇଂରାଜୀରେ ଲେଖିଲେ ଗୋଟେ ଆଉ ଗୋଟେ ଏ ଦବାକୁ ପଡିବ।
ଏଇଟା ହଉଛି
ଏଇଟା ତ ଡିଫରେନ୍ସ।
ସି ହେଲା respondent has further declared about the Mauja Unit 13 Chandini Chowk, Cuttack, khata number 799, plot number 220 and 221, but there is no plot number 221 in khata number 799 as per the ROR downloaded from the official website, that is Bhule.
ଏଇଟା କଣ କହିବାକୁ ଚାହୁଁଛନ୍ତି?
ଏଇଟା ସେ ଖାତା ନମ୍ବର ଦେଇଛନ୍ତି 799 ଦେଇଛନ୍ତି, ପ୍ଲଟ ନମ୍ବର ବି 220 221 ଦେଇଛନ୍ତି। ସେ ଗୋଟିଏ କବଲାରେ କିଣିଛନ୍ତି, ସେଠି ଖାତା ନମ୍ବର 799 ଆଉ ଗୋଟେ ଖାତା ନମ୍ବର 48 ଆସୁଛି 221 ଟା, 799 ଆସୁଛି 220।
ସେଇ ଯୋଉ ଏଇଟାକୁ ଓମିଟ ହେଇଯାଇଛି, ଗୋଟେ ଖାତା
ନମ୍ବର ଆଉ ଠିକ ଅଛି, ଆଉ ସବୁ ଠିକ ଅଛି।
କିନ୍ତୁ ଏଇ ଯୋଉ ଜାଗା ଠିକ ଅଛି, ମୌଜା 13 ଚାନ୍ଦିନୀ ଚୌକ ଏଗୁଡା ଠିକ ଅଛି,
ସବୁ ଠିକ।
ଓକେ ଓକେ।
ଆଉ ଏଇଟାକୁ ଆମେ ରିପ୍ଲାଏ ଦେଇଛୁ ପାରାଗ୍ରାଫ 23E at page 65 to 71। ନା ଏଗୁଡା ସେଇ ଡିନାଏଲ ଖାଲି ଆମେ
ଖାଲି ଇଏଟା କହିଦିଅନ୍ତୁ ଆପଣଙ୍କର ଇଏର ରିଟିନ ଷ୍ଟେଟମେଣ୍ଟ ର
23E
କ୍ୟାପିଟାଲ ଇ,
23E କ୍ୟାପିଟାଲ ଇ ତ
ପେଜ 65 ରୁ 71,
କ୍ୟାପିଟାଲ ଇ ତ
ଆଜ୍ଞା
ପେଜ
65 ରୁ 71,
65 to 71
ଆଜ୍ଞା। ଦେନ୍
ତାପରେ ଡକୁମେଣ୍ଟାରୀ ଏଭିଡେନ୍ସ ସେମାନେ ଯୋଉ ଦେଇଥିବେ
ଇସ୍ୟୁ ଗୁଡାକ
28
29
issue number 28 29
30 and 33
33
30 and 33
ହଁ ଲେଖିଲେ 28 29 30 33
ଆଜ୍ଞା। ତାଙ୍କର ଡକୁମେଣ୍ଟାରୀ ଏଭିଡେନ୍ସ ହଉଛି ଏକ୍ଜିବିଟ୍ 5
ଓନ୍ଲି ଡକୁମେଣ୍ଟ।
ଆଜ୍ଞା।
ଯୋଉଟା ସାର୍ଟିଫାଇଡ କପି ସେ ପାଇଛନ୍ତି 7/7/2022।
ସେ ଏକ୍ଜିବିଟ୍ 5 ଟା ଟିକେ ବାହାର କର, ଟିକେ ଦେଖିବ। ଅଡି ଉପରୁ ସେଟା ଏକ୍ଜିବିଟ୍ 5 ଲେଖା ହେଇଛି। यूनिट नंबर 13 चांदनी चौक ठीक अच्छी। बाकी एटा रहिला इजाज अली पिता शायद इरफान अली स्वानसो वाला
ये लोग बिकिचंती।
हाँ 7
माने आरोटा जे म्यूटेशन ही करेक्शन है। सेटा ता अभरमेंट भी नहीं रे इजाज का नार अछि बोली। सब्सिक्वेंटली से आनी जंती ताको एविडेंस। without any pleading.
अच्छा এই जोटा सी लिख दीचंदी एटा या परे
କବଲା ହେଇଛି
अच्छा कबला ହେଲା ପରେ ପୁଣି ଚେଞ୍ଜ ହେଇଛି ଚେଞ୍ଜ ହେଇନି ଆଚ୍ଛା ସେଇ କ୍ୱେଶ୍ଚନ ରହି ମ୍ୟୁଟେସନ ହେଇନି ତେଣୁ ROR stands in the name of Ijaz Ali but by virtue of that cell deed it came
ସେଇଠି ଦେଖନ୍ତୁ ତାପରେ ଅଛି ପରପେଷ୍ଟରେ ଗୋଟିଏ ପ୍ଲଟ 220 221 ନାହିଁ ସେ ଗୋଟାକୁ ଧରି
ସେଇଟାକୁ ସେ ଆଉ ଗୋଟେ
ସେଇ ଯୋଉ କବଲାଟା ଆମେ ଏକ୍ଜିବିଟ କରିଛୁ
Exhibit 43, he declared khata number 799 having plot number 220 and 221.
हाँ से जो 221 टा सेटा पूरा आउ गोटे खाता
21 से खाता number देने. So our argument is that khata number 799 does not holds that plot number 220.
by that you are right माने 779 ने 221 बोली किछि plot number 9 you are right.
So that is the false amount in the declaration in the affidavit.
They are according to them that is in another khata. So inadvertently it has been mentioned by
କବଲାଟା ଆମେ prove କରୁ
କବଲାଟା ଦେଇକି
ସେଠି ମାଇଣ୍ଡ ଦେଖିବେ ଯଦି ଏକ୍ଜିବିଟ୍ 38 ନନ୍ ଏଗ୍ରିକଲଚର ଲ୍ୟାଣ୍ଡରେ ସେ ଦଉଛନ୍ତି ଦବା ପାଇଁ ଓନ୍ଲି ଲୋକେସନ ଆଣ୍ଡ ସର୍ଭେ ନମ୍ବର ଆମେ ଲୋକେସନ ଦେଲୁ ଚାନ୍ଦିନୀଚୌକ ସର୍ଭେ ନମ୍ବର ଦେଲୁ ପ୍ଲଟ ନମ୍ବର
ତାଙ୍କର ଇଏଟା ହଉଛି ପରା
ଖାତା ନମ୍ବର ଦବା ଦରକାର
ସେଇଠୁ ଗୋଟେ
ଖାତା ନମ୍ବର ହଁ ସେ ଆପଣ ଖାତା ନମ୍ବର ଦେଇକି ତା ଅଣ୍ଡରରେ ଯୋଉ ଦିଟା ପ୍ଲଟ ଦେଇଛନ୍ତି ଗୋଟେ ପ୍ଲଟ ଇନକ୍ଲୁଡ କରିଛନ୍ତି ଯୋଉଟା କି ସେ କହୁଛନ୍ତି
221 ଟା 48 ଖାତାରେ ଅଛି
ସେଟା ଭୁଲରେ ଦେଇଛନ୍ତି ସେଟା କହୁଛନ୍ତି ଫଲସ
ଓମିଶନ ହେଇଯାଇଛି ବୋଲି କହୁଛନ୍ତି ଫଲସ
ଅଲ୍ ରାଇଟ୍ ନେକ୍ସଟ
ହେଲା ଆମେ ଦେଇଛୁ ଡକ୍ୟୁମେଣ୍ଟ ଏକ୍ଜିବିଟ୍ ଏମ୍
ଜଷ୍ଟ
ଏକ୍ଜିବିଟ୍ ଏନ୍
ଏକ୍ଜିବିଟ୍ ଏମ୍ ଟା ମାଇଲ ସେଇର ଡାଉନଲୋଡେଡ ROR ଟା ଯୋଉଟା କି ଇଲେକ୍ସନ ପିଟିସନଙ୍କ ତରଫରୁ ଫାଇଲ କରାଯାଇଥିଲା ଏବଂ ସେଟା ଡାଉନଲୋଡ ହେଇଛି 28/6/2000 କେତେ
ସେମ୍ ପୋଜିଶନ ଦେଖଉଥିବ ନା
ହଁ ଇଲେକ୍ସନ ପିଟିସନରେ ଲେଖିଲେ ଯେ ଆମେ ଡାଉନଲୋଡ କରି ଦେଖୁଛୁ କିନ୍ତୁ ସେ ଡକ୍ୟୁମେଣ୍ଟ ଆପଣଙ୍କ ପାଖରେ ଦାଖଲ କଲେ ନାହିଁ ସେ ଯୋଉ ଏକ୍ଜିବିଟ୍ ଏମ୍ ଟା ଆମେ ଦାଖଲ କଲେ ଆମେ ଆମ ତରଫରୁ କଲୁ ସେଇଟା ସେ ଡାଉନଲୋଡ କରିଛନ୍ତି ପରେ
ଏକ୍ଜିବିଟ୍ ଏମ୍ କଣ ଦେଖଉଛି
ଏମ୍
ଏମ୍ ଯାହା ଏକ୍ଜିବିଟ୍ 5
ସେଇଆ ତ ମୁଁ ସେଇଆ
କିନ୍ତୁ ସେ ଯୋଉ ଡାଉନଲୋଡ ଡେଟ୍ ଟା ଦେଖିବେ that has been downloaded on 28/6/2022 ଇଲେକ୍ସନ ପିଟିସନ has been filed on 3/7/2019 ଏବଂ ସେମାନେ ଆଭରମେଣ୍ଟ ଦେଲେ ଯେ ଆମେ ଡାଉନଲୋଡ କରିକି ଦେଖୁଛୁ ଏଥିରେ ନାହିଁ
so that part is not correct
yes
all right
ତାପରେ ଏକ୍ଜିବିଟ୍ ଏନ୍ ଏକ୍ଜିବିଟ୍ ଏନ୍ ଏକ୍ଜିବିଟ୍ ପି
ଏଲ୍ ଅଛି
ନାଇଁ ଏନ୍ ପରେ ପି ମାଇ
ପି ହଁ
ଏକ୍ଜିବିଟ୍ EF
ଆଜ୍ଞା
ଯୋଉଟା କି ପାଟପୁର ଆମେ ଦଉଛ ସାର୍ଟିଫାଇଡ କପି ଅଫ ROR ପାଟପୁରର ଅଛି ଏକ୍ଜିବିଟ୍ EG
ଆଜ୍ଞା EG
ଏକ୍ଜିବିଟ୍ K ଏକ୍ଜିବିଟ୍ K ଟା ହଉଛି 769 ଡାଉନଲୋଡେଡ କପି ସେ ଯୋଉଟା ଦେଇଛନ୍ତି ସେଟା ଡାଉନଲୋଡ କରୁଛନ୍ତି 28/6 ରେ କୋର୍ଟରେ ଫାଇନାଲ କରିଛନ୍ତି 29/6/2022 ଆଫ୍ଟର ଫାଇଲିଂ ଅଫ ଦି ନୋଟିଫିକେସନ ଏଇ ଯୋଉ ଇଲେକ୍ସନ ପିଟିସନ
ତାପରେ ଓରାଲ ଏଭିଡେନ୍ସ ତାଙ୍କର ମୁଁ ଦଉଛି ରେଫରେନ୍ସ ହଜୁର ଖାଲି ଦେଖିଦେବେ PW1
evidence on
affidavit exhibit 36 paragraph 24 page 18 paragraph 25 page 18 to 19 examination in chief of PW1 paragraph 39 cross examination of PW1 paragraph 83 page 37 to 39 Paragraph 84, page 39 and 40. Paragraph 85, page 40, 41. Paragraph 86, page 42 to 44. Paragraph 96, page 52. Satik.
Yes.
Then comes 7F.
Paragraph 7F.
Again. Available at election in the election petition at page 14.
14 to 16.
Election
14 to 16.
Page 14 to 16. Election petition of Arsenal. Page 14 to 16. Row. एक फर्क है ले
I have categorized it to 3 categories, A, B, C. Entire pleading A in paragraph 7B, IV, the respondent has declared about the residential building known as City Shelter in the district of Kotak, Mauza Town, Unit 15, plot number 1882 by 3019, 2743, 1882 by 3020, ground floor, flat number 1A, 2B, F5. In the above declaration, the respondent has not declared the khata number. Amar koti khata number dabaku instruction nahi of the above said plots, whereas in the declaration made in respect to his spouse, he has declared the serial number 2 khata number 479, 480, plot number so and so. In serial number 3, he has mentioned khata number 992 with respect to plot number so and so, so and so, so and so. The respondent has mentioned about the above said plots in 3 khatas, which are false declaration, as all the above plots cannot be recorded in 3 different khata of the same murza. ମୋର ଗୋଟେ ଖାତା ଦବାର ନାହିଁ କିନ୍ତୁ ମୁଁ ଯଦି ଅଧିକନ୍ତୁ ଦେଇ ଦେଇଛି you cannot find fault with that. ତାପରେ B, respondent has not declared in his affidavit filed in form 26 along with the nomination paper about the loans taken by the companies in which he himself and his spouse are the directors. The respondent company has taken huge amount of loans from Odisha Rural Housing Development Corporation when the respondent himself was the managing director of Metro Builders Private Limited. The respondent has suppressed to disclose the above facts in the affidavit filed in form 26. এটা pleading ରେ ତାଙ୍କର ନାହିଁ.
এটা pleading ନା ତାଙ୍କର
pleading
ଏଇଟା ହଉଛି format ରେ ନାହିଁ.
format ରେ ନାହିଁ.
format ରେ ଯୋଉ company ର ଏଟା ଦେଖିବା ପାଇଁ ନାହିଁ. format ଟା ଦେଖିଦେବି ମାଇନ୍.
When statement so when the respondent for the mandate. আচ্ছা
এটা liability ଟା ଦେଖିବାକୁ ଅଛି.
এটা হচ্ছে
exhibit 39.
39 दबा दो.
serial number 2 ରେ ଥିବ.
exhibit 38 ର
38 ର
ଦେଖିବେ liabilities ଯୋଉଠି ରହୁଛି ସେଟା ହଉଛି column 8 starts from page 372 of the handbook for returning officer.
ଆଜ୍ଞା
bottom କୁ ଦେଖନ୍ତୁ. I have given below
just a minute. I have given below the details and liabilities due to public institution and government. Please give separate details of name of bank, institution, entity or individual and amount before each item. आधेर कौन भूल
देखନ୍ତୁ ଟେବୁଲ ଟାକୁ ଅଛି next page ରେ just the next page. से देबे सेल्फ रो हेडिंग देखो सेल्फ रो देबे स्पाउस रो देबे हिंदू अनडिवाइडेड फैमिली देबे और डिपेंडेंट माने कर देबे कंपनी रो दबा ପାଇଁ कोनोसी इंस्ट्रक्शन नहीं बा कॉलम नहीं प्रोवाइड की
He himself is the managing director
of a company
of the company. So
कंपनी जे
निज हेडिंग रे देइछि
ना से दर्शई ना
अच्छा
कंपनी जे सेपरेट लीगल एंटिटी
हमको सेटा दबा दरकार नहीं
अच्छा
आवारे
आज
रिप्लाई
आज आज मैनेजिंग डायरेक्टर आनिले मध्य but
कंपनी
since there is no
लोन टा
company
कंपनी
आगे अब ये जो 7F रो रिप्लाई की
तापर ताकर प्लीडिंग देखंतु सेटारे the respondent himself was the managing director was past said माने प्लीडिंग से नउचंती was the managing director आज दिन रे managing director अछंती देई नाहंती से कथा तांगा प्लीडिंग नै
नहीं रिलेवेंट ही था जोडनो नॉमिनेशन पेपर फाइल करले
आगे
हां
से लिखुचंती तांगा इलेक्शन पिटिशन प्लीडिंग रे was the managing director not is the managing
whether on the date of filing of nomination सेटा कोन
that amendment should have been taken
should have been there C column 11 of part B of affidavit respondent is required to declare the abstract of the details given in 1 to 10 of part A and in column 8I he is to declare the purchase price of self-acquired immovable properties of himself and his spouse. The respondent, while declaring the purchase price of self-acquired immovable property of his spouse, has declared not applicable. He has not declared the purchase price of the self-acquired property by his spouse. He has also not declared the development, construction cost, and immovable property after purchase of his spouse. तांकर allegation किछि नाही कि तुमे इन्वेस्टमेंट करिଛ towards construction in the property purchased in the name of your spouse.
लिखले मैं नोट से फॉर्मेट आउट देखो पार्ट बी को जानतो पार्ट बी रो कॉलम 11 पार्ट बी स्टार्ट्स फ्रॉम पेज 376 column 11 available at page 377 से लिखले column 11 of part B part B रो column 11 कहूची highest educational qualification
कोडा कोडा कहउनी
पार्ट बी का कहले ना
पार्ट बी रो कॉलम नंबर 11 तो
हां त नेक्स्ट पेज रे अछि
हां नेक्स्ट पेज सेटा अछि लायबिलिटीज गोटे अछि हेडिंग
ना 11 कॉलम 11 देखंतु पार्ट बी पर 1 2 3 4 चलला 11 होची हाईएस्ट एजुकेशनल क्वालिफिकेशन
हां हाईएस्ट एजुकेशनल क्वालिफिकेशन
से जोटी मेंशन करिया कहउचंती जे जो कॉलम 11 रे column 11 of part B of the affidavit, the respondent is required to declare the abstract of the details given in 1 to 10 of part A. That is not correct. Then to declare column 8I, सेठी देखंतु सही 376 नंबर पेज रे सेटा होची column 8BI. Column 8
So
पर
the
A
pleading
अछि
itself is defective.
column 8 रे A रे लिखबे movable assets B रे लिखबे immovable assets से स्मॉल आई लिखिचंती एठी कैपिटल आई कैपिटल डबल आई कैपिटल ट्रिपल आई हमर स्पेसिफिक कथा होची जे एठी एक्चुअली तांको स्त्री को जगह रे से इमूवेबल एसेट्स टोटल प्राइस ता लिखि दैचंती आई 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 जगह रे ट्रिपल आई जगह रे नॉट एप्लीकेबल करचंती That is fact, but documentary documents যা কହୁଛି কিন্তু এই ফিগরটা সে পার্ট এ রে ଦେଇଛନ୍ତି, that is available in part A. ঠিক
Then our reply to 7F is in paragraph 23F. At page 23F, capital F, page 71 to 80. Say A, B, C କରିକିରି ମୁଁ denial କରିଦେଇଛି. Then this reading covers issue number 28, 30, 31, 32 and 33.
Issue number la kete 30,
28,
28,
30,
yes,
31, 32, 33. ପାଞ୍ଚଟା issue. ସିଏ documentary evidence ଦେଇଛନ୍ତି in support of these issues. Exhibit 7, Exhibit 8, Exhibit 9.
7, 8, 9 by election petition.
ଆଜ୍ଞା ଆମେ ଦେଇଛୁ Exhibit Q,
Documents by respondent.
Exhibit Q, Exhibit R, Exhibit S, 18 note. ତାପରେ ତାଙ୍କର oral evidence PW1, evidence in affidavit Exhibit 36,
36.
paragraph 26, page 10 and 19 and 20.
total 26 ହଉଛି beyond pleading.
Page 20 କେତେ କହିଲେ?
19 and 20 19 ବୋଲି.
କୋଉଟା total beyond pleading କହୁଛନ୍ତି?
Paragraph 26.
26.
ଆଚ୍ଛା, beyond pleading, okay.
Paragraph 27 at page 20 and 21.
ସେଥିରେ most of portions beyond pleading ଆମେ ତାକୁ italic କରିଦେଇଛୁ.
20 and 21.
ଆଜ୍ଞା paragraph 28,
yes,
page 19 and 20. 28 ର total paragraph beyond pleading.
28 beyond pleading.
ଆଜ୍ଞା paragraph 29 at page 22, all averments are beyond pleading.
29.
ଦେଖିଲି.
Paragraph 30 at page 23, major portion beyond pleading. Paragraph 31, page 24 and 25.
Para
24 and 25.
Para 31 man.
Para 31, page 24 and 25. ତାପରେ examination in chief of PW1. Paragraph 39, page 2. Major portion beyond pleading. We will show it in the note. Paragraph 41, entire paragraph at page 6, entire paragraph 41 is beyond pleading.
41 na 42?
41.
Page 6. 41 total টা beyond pleading.
Okay.
ছোট paragraph.
তারপরে cross examination of PW1, paragraph 87, page 44, 45. Paragraph 88, page 46.
ପ୍ରଥମଟା ହେଲା 85 ନା?
ଆଜ୍ଞା 87 ମାଇନର
ହଁ ପ୍ରଥମଟା ସରି ପ୍ରଥମଟା ହେଲା 87 ତାପରଟା କେତେ କହିଲେ
88
88
88 ପେଜ 46 paragraph
89 page 46 90 page 46 91 page 46 and 47 92 page 47 bottom to page 48 93 paragraph 93 page 48 paragraph 94 page 48 bottom to page 49 paragraph 95 page 50 and 51 paragraph 96 page 52 paragraph 97 page 42 bottom to page 46 56 52 bottom to 56 paragraph 98 page 57 to 61 our submission. It is only submitted on behalf of the sole respondent that so far as allegations made under paragraph 7D, 7E, 7F composite are concerned, the election petitioner has signally failed to prove and substantiate the allegations under these three paragraphs. It is further submitted on behalf of the sole respondent that whatever minor mistakes have been pointed out with respect to the allegations made in the above mentioned three paragraphs have to be ignored as the same are not a defect of substantial character. The last submission is what a judgment ଦଉଛୁ ଆମେ ତାରି ଉପରେ substantial character ନଥିଲେ ତାକୁ ignore quote କରିବେ.
ଏଇଟା ହଉଛି my lord civil appeal number 3710 of 2023 3710 of 2023
yes yes
paragraph 1
civil appeal number 3710
of 2023
Patina judgment ଅଛି
decided on 19 October 2023
versus
ଦି ମାସ ତଳର
blue pool versus
ଏଟା କୋଉ paragraph ଟା କହିଲେ
1 3 to 14 16 17 and 18 my last submission is
just as noted, we have indicated that the contention of the respondent in the present fact that it would amount to non-disclosure and therefore a defect of substantial character cannot be accepted. And since in that circumstances it is not a case of improperly accepted nomination, it has not materially affected the result of the election, as so and so. Further, in the object in the response as required disclosure of assets in keeping with the fact therein involved indicate that the allegation therein cannot be taken as non-disclosure. It have been open to indicate this aspect in the affidavit, but in any event, it is not.
ଏଠି ହାଇକୋର୍ଟ ସେଟା ସେଟ୍ କରିଦେଇଥିଲେ ଇଲେକ୍ସନ ଟା ସେ ତାଙ୍କର ସ୍ପାଉସ ଜାଗାରେ ହଜବାଣ୍ଡଙ୍କ ଜାଗାରେ ସମ୍ପତ୍ତିରେ ନଟ୍ ଆପ୍ଲିକେବୁଲ କରିଦେଇଥିଲେ ବଟ୍ ଆପଣ ଲାଷ୍ଟ ଦେଖିବେ 16 17 18 ପାରାଗ୍ରାଫକୁ ଅନରେବୁଲ ଆପେକ୍ସ କୋର୍ଟ କହିଲେ ଇଟ୍ ଇଜ ନଟ୍ ଏ ଡିଫେକ୍ଟ ଅଫ ସବଷ୍ଟାନ୍ସିଆଲ କ୍ୟାରେକ୍ଟର.
So, the property has been indicated, but that Moja or something like that, like
खाता नंबर को
खाता
मिस
number
करछोदि
କୋଉଠି?
एतिକି हा खाता नंबर
substantial nature
that is not of substantial
एठी
nature.
मूळुरु देई नथिले नॉट एप्लीकेबल कर दे
Hmm.
ता सत्य मध्ये अपेक्स कोर्ट कहले
Not applicable माने सी तांकर स्त्री को हेडिंग रे देई दी
लेडी
हां निज हेडिंग रे देई नथले जदियो से प्रॉपर्टी टा जॉइंट नेम रे अछि ना कोन
नहीं ताको हस्बैंड का ना
हस्बैंड का नाम दे
अच्छा
प्रॉपर्टी देई नथिले
सेटा को डिस्क्लोज कर
ओहो
my last submission before
Yes.
your lordship is my lord in a election case
এটা seal মারি কি না না yes
under 51 act
hmm.
the burden of proof
Hmm.
lies on the election petitioner
Hmm.
to get the reliefs.
Hmm.
If he has failed to prove those burden, discharge that burden, then he is not entitled to anything.
Hmm.
Reliance is placed on
लाटी दिटा डिसीजन में देइथिलु देइ दउछ
एबे हां आफ्टर दिन and दीटा डिसीजन ଆମେ ଦଉଛୁ
आज्ञा
ଏଇ ଆଣ ସେଳିଆ
ଗୋଟା ହଉଛି 2001 ର ଗୋଟା ହଉଛି 2010 ର
2001 ର କେତେ
2001
3
SCC 290
हां
टेकचांद वर्सेस दिलेराम टीके टेकचांद वर्सेस दिलेराम आर पैराग्राफ में लॉर्ड 1 3 7 रु 9 14 26 27 40
अंडरलाइन कर दीजन तो
ठीक है एटा हमें देइथिलु जतेबेले हु विल स्टार्ट फास्ट आपण मध्ये को एप्रिशिएट करिकि लिखिचंती जजमेंट देइथिले किंतु सीपीसी अनुसार हमकु देले
71T
M चंद्रा वर्सेस M थंगामुथु एंड अनदर 2010 9 SCC 712
712
यस
ସେଥିରେ paragraph गुड़ा सर लिखले underline while parting with the brief attention of the honorable court is drawn to the very fact that this respondent won the election as per verdict of the majority people and declared elected on 23/5/2019. However, the election petitioner has been consistently and repeatedly continuously harassing the sole respondent by filing a frivolous election petition for which the sole respondent has been seriously obstructed in performing his duties as a people's representative wholeheartedly for implementing and executing the welfare programs for betterment of the electors, citizens of the 90 Baravati Kotak Assembly constituency. आउ गोटाए आमे नेइछु प्लीडिंग रे जजमेंट भी देई दउछु सेतरे होची नै से एटारे देई दउ मैंडेट्स ऑफ द पीपल कैन नॉट बी लाइटली इंटरफियर आउ गोटे अछि आमे प्लीडिंग रे नेइछु जे exact copy and true copy.
Issue number 3 टा रही
Issue number 3 टा exact copy and true copy जदि देई नथिबो election petitioner ताले it will be liable to be dismissed.
सेटा section 81(3) रे section 81(3) रे कहले कि जो कॉपी सर्व करिवे सेटा को हां
ठीक है देखिए
Every election petition shall be accompanied by as many copies thereof as there are respondents mentioned in the petition, and each such copy shall be attested by the petitioner
under his
own signature to be a true copy of the petition. कौन आदेर भूल रही छी?
अपन तपरे माइनर आसंतु section 117
चालान भी दो
section 82(3) of RPR आउडा कोडा
section 81(3) लिखले तो
81(3) पा
then section 117
Along with the petition, he will file the challan.
117.
Security for cost.
Just a minute. 117 security for cost.
Again.
Section 117. हाँ कौन हला अधीर?
At the time of presenting an election petition, the petitioner shall deposit in the High Court in accordance with the rules of the High Court a sum of 2,000 rupees as
এটা পরে ডিসাইড হইতলা সে যে ইয়েরে
no, that is pending. That is pending. Another IA is pending. এটা যেটা আমি কହୁଛେ
ওকে
এটি এক্সিবিট করা যাইছে
কারণ ଆର୍ଜିଙ୍କୁ କୁହାଯାଇଥିଲା ଗୋଟେ ରିପୋର୍ଟ ମଗାଇଥିଲା ସେ ଦେଇ
ଆମେ କହୁଥିଲୁ ଦେଇ ନାହାନ୍ତି ଫାଇଲ ବେଳେ
ହଁ
ସେତେବେଳେ ଆପଣ ରେଜିଷ୍ଟ୍ରିଂ ରୁ ମଗେଇଲେ ସେ କହିଲା ସେ ଦେଇଛନ୍ତି
ଦେଇଛନ୍ତି ତା ପୂର୍ବରୁ ଦେଇଛନ୍ତି ସବୁ
ତାପରେ କହିଲୁ ଆମକୁ ଯୋଉ କପି
ଆମକୁ ଯୋଉ କପି ଦବା କଥା
ସର୍ଭ କଲେ
ସେଥିରେ ନ
ସେଇଟା ଏକ୍ସିବିଟ୍ ମାଇ ଲର୍ଡ ମାର୍କ ହେଇଛି
during the High Court. You mean to see that
ସିଏ ଦେଇଛନ୍ତି
deposit copy has also to be furnished to the other side
along with the election petition upon the other
that
side.
is the part of the election petition.
ସେଟା କୋଉଠି ଲେଖା ହେଇଛି
ସେଇଟା ଦେଖିବେ ଆମ
because of that ଯୋଉ ଆପଣ interpret କରୁଛନ୍ତି 81(3) କୁ
81(3) କୁ
every petition shall be accompanied by sworn so acha and every such copy shall be attested on
Okay, my lord, তিনটা ডকুমেন্ট আপনি এক্সিবিট করছেন এক্সিবিট এ ডি A capital D that is the original election petition. Then exhibit AD by 1 সেটা হচ্ছে original challan appended to the original election petition.
Yes.
Then exhibit AB capital A capital B সেটা হচ্ছে election petition served upon the respondent through process of through process of court by special messenger. Exhibit AB by 1 someone appended to exhibit AB. Then exhibit AB by 2 deposit challan appended to exhibit AB. AB by 2 ठाउ जे हमें कहूछु सेटार पर डिस्प्यूट करूछु. Then I would have to exhibit A capital C. Capital A capital C. Set out the election petitioner sent through speed post to the respondent. Exhibit AC by 1. The court summon. Exhibit AC by 2. It was a copy of the deposit challan. Compare exhibit AD by 1 original challan that with the exhibit AB by 2 and AC by 2 say जो receive payment stamp ta जो cashier करो that is not available in exhibit AB by 2 as well as exhibit AC by 2 जोटा कि election petitioner ମଧ୍ୟ ମାନିଛନ୍ତି ତାଙ୍କ
ହଁ ସେଇଟା ତମାନେ ଆଗରୁ ଜେରକ୍ସ କରିକିନି କପି କରିକିନି ଦେଇ ଦେଇଛନ୍ତି ଯୋଉଟା କି
ବିଫୋର ପେମେଣ୍ଟ
ହଁ ବିଫୋର ପେମେଣ୍ଟ ହଁ
ତେଣୁ ଯଦି 81(3) ରେ ସେ ଟ୍ରୁ କପି ହଉ ନାହିଁ ଦେନ୍ ମାଇ ଲର୍ଡ ଟି ଆସନ୍ତୁ 86(1) କୁ ସେକ୍ସନ 86(1)
81 କମ୍ପ୍ଲାଇ ନହେଲେ ଯୋଉ ଡିସମିସ୍ କରିବ
ଆଜ୍ଞା that is our technical ground. We'll try to supply
all right.
judgment.
Yes, Mr. Mishra, anything further?
Nothing. खाली मु एतिकी आपनको रिक्वेस्ट करी we are still having 1 day more 10th if necessary मु टिके आ भितर देखि देबी काले कोटा छाडी जाई जदि मु न छाडिली से तांकर 11 रु आरंभ करिवे बिगिनिंग जदि किछि थिबो I will seek your lordship's indulgence for 15 minutes to indicate that.
On
11 तारीख
11 तारीख
हमें काली टिके चेकअप कर दो किछि रहि गेला कि नहीं
no 11th ru to let them start you want to that beginning 15 minutes it's all right there is no
जदि थिबो
हां जो नथिबो नचे से माने आरंभ करिवे because your date is till tomorrow. Okay so लिखि देबे
अब काली पोस्ट करिवा दरकार
हाँ
କାଲି ପୋଷ୍ଟ
ନାଇଁ
କରିବେ
ନାଇଁ ନାଇଁ ଏଟା ଲେଖି ଦିଅନ୍ତୁ ଯେ ସେଇ ଯୋଉ ଯାହା ଅର୍ଡରଟା ଥିଲା ସେଟା ଲେଖିଦେବେ ଦି Mr. Mishra, learned
କିଛି ନାହିଁ
senior advocate for the election petitioner, though concluded his argument, but submitted that he will verify the records once again, and if anything is left out by him, he may be allowed to make the submission on 11th January 2024, which is the date fixed for the election petitioner commence his argument. In view of such submission, list
15
this.
minutes ବେଲେ ବି ଥାଏ ମୋର ଆଉ ଅଧିକା
15 minutes. In view of such submission, list this matter on 11th January 2024 at 2 p.m. Okay.
and after reply ଯୋଉ ଦିନକୁ ଆପଣ କହିବେ note of argument ବି ଆପଣ ଉଭୟ ପକ୍ଷ ଦେଇଦେବେ
It should be simultaneously ମାନେ you carry on କାରଣ ଯୋଉ ଦିନ
ନା ଆମେ କରୁଛୁ
ହଁ ବାସ୍
ଆମେ କରୁଛୁ
ସରିଯିବ ମାନେ ତା ମାନେ ନୁହେଁ ଯେ ସେ ହଁ ମାନେ ମୁଁ କହିବା କଥା ଯେ ଆର୍ଗୁମେଣ୍ଟ ସରିଲା ପରେ ପୁଣି ଆଉ 15 ଦିନ ଆମକୁ ଦିଆଯାଉ ଯେ ଆମେ ନୋଟ ଦବୁ ଏସବୁ ଯେମିତି ନବା ଆପଣ ସାଇମଲ୍ଟେନିୟସଲି ପ୍ରିପେୟାର କରିଦେବୁ
ଆମ ପାର୍ଟଟା ମାଇଲଟ କରିଦେଇଛୁ ସେ ଯାହା ଉଠେଇବେ ତାକୁ ରିପିଟ୍ କରିବା ପାଇଁ
ଇଟ୍ସ ଅଲ୍ ରାଇଟ୍
ତାକୁ ପୁଣି ଇନସର୍ଟ କରିବା ପାଇଁ ପଡିବ
So
it will definitely both party will require after close of argument by both the parties minimum 3-4 days.
Okay.
Not much.
Now we come to the weekly list.
ଲାଷ୍ଟ ସବମିଶନ ଟା ଯୋଉ ରହିଲା ଟେକ୍ନିକାଲ ଗ୍ରାଉଣ୍ଡରେ ଏଟା ଇସ୍ୟୁ ନମ୍ବର 3 ଥିଲା ଇସ୍ୟୁ
ଲେଖିଛି ପରା Now start from item number 1 ସରିଯାଇଛି 2 ରୁ ଆରମ୍ଭ just ଗୋଟେ minute 2 minute ମାର୍ସି
We beg leave.
I'm just coming within 2 minutes. Okay?
Supplemental list item number 2.
May I please, your lordship? Last one on 5 January, my lord, to to one Lipunu Patra and second Joy Krishna Patra deposition was finished, my lord. Already certificate applied, my lord.
Yes.
16 तारिख deposition ସରିଯାଇଛି ଏରା certificate ଗୁଡ଼ା apply ହେଇଛି 16 ତାରିଖ
The Learned Counsel for the appellant submitted that the witnesses Jayakrishna Patra and Lipun Patra have already been examined in the Learned Trial Court, and he may be given some time to produce the certified copies of their deposition. Put up this matter in the week commencing from
16 ଆଜି ପଳେଇ ଆସିବ
16th or next week.
ଆଜ୍ଞା
ଆଣିପାରିବେ?
ଆଜ୍ଞା ଆଜି ପଳେଇ ଆସିବ
All right. 16/1/2024. The copies of the deposition shall be furnished to the Learned Counsel for the state. Yes.
Item 3.
Item number 3, may I please, your lordship? The petitioner
Yes,
is in
just a minute. Sufficiency of notice on sufficient lagi?
Yes, sir. 15
You
12
are
23.
appearing.
petitioner was released on
Custody
interim bail.
certificate ଅଛି କି?
Yes. Custody certificate.
କୋଉ jail ଅଛି?
Sub jail no. My lord, it was mentioned in the earlier application also. By order dated.
Order dated? କୋଉଥିରେ mention ହେଇଛି?
Earlier interim bail ଯାଇଥିଲା. Investigation of 544. Order to 111.
544. କିଛି ତ ନାହିଁ, ଗୋଟେ IA number 2144 ରହୁଛି।
214 ରେ interim bail ସେ avail କରିନଥିଲା, ତେଣୁ report call କରାଯାଇଥିଲା। 5444 ରେ ସେ bail ଯାଇଥିଲା।
544.
My lord.
544 ହେଲା, yes, that is order dated 1/11/2021.
My lord.
10 years ରୁ ଆପଣ ଆଚ୍ଛା ସେତେବେଳେ ହେଇଥିଲା 6 years 6 months.
My lord.
ଆଚ୍ଛା ତାପରେ ବେଲ୍ ଗଲେ ନା 3 ମାସ ଗଲେ?
My lord.
ତ 11/4/2015 ରୁ ଆଜିକି ହେଲା 8 ବର୍ଷ 8 ମାସ ହଉଛି, ବଟ୍ ତା ଦେହରୁ 3 ମାସ କଟିଗଲେ 8 ବର୍ଷ 5 ମାସ ହଉଛି।
8 years 5 months 28 days.
ଓକେ। ଲୋକ କୋଉଠିକାର?
My lord, Kolahan.
Kolahandia. IA number so and so, there is an application for bail considering the submission made by the land council for the petitioner that the out of 10 years of substantive sentence imposed by the London trial court, the petitioner has already undergone more than 8 years of substantive sentence, and after availing the interim bail order, surrender at right time, is a local man. There is no chance of early hearing of the appeal in the near future. I'm inclined to release the petitioner on bail allowed. Yes.
Obliged.
Item 12.
Petitioner has been convicted under section 3762I and 4/6 of the POCSO Act. Actually, the order
Item 14.
Yes.
May I please, Your Lords? I am for the sub-item, my lord. Criminal appeal number 230 of 2020.
Sub-item means Sanjeev Kumar Dehuri.
My lord.
Bail
Convicted for 10 years, my lord, under section 20B2C.
କେତେ ରହିଛନ୍ତି?
And inside custody, my lord, during trial, petitioner was on bail, my lord. And my lord, petitioner was arrested, my lord, 2011-2016.
ବେଲ୍ ଥିଲେ ମୋର ଟୋଟାଲ ପିରିୟଡ ଦରକାର, ଆପଣ କେତେ ନେଇଛନ୍ତି ନା ମୁଁ ଆଣିବି? custody certificate
custody certificate ମଗା ହେଇଥିଲା
ମଗା ହେଇଥିଲା ଆସିଲା କି ହଉଛି
କଷ୍ଟଡି ସିନ୍ସ 28/3/20
the date of judgment
28/3/20 ହେଲେ ଆପଣଙ୍କର ତ ହଉନି 3 ବର୍ଷ କେତେ ମାସ ହଉଛି 3 ବର୍ଷ maximum ଏଇ 9 ମାସ ହବ 3 ବର୍ଷ 9 ମାସ
during trial he was on bail my lord
ହଁ ହାଫ୍ ହେଇନି ନା ହାଫ୍ ହେଇଯାଉ ଏଟା ସେତେବେଳେ କେତେ କେବେ କଷ୍ଟଡି ନିଆ ହେଲା କେବେ ବେଲ ହେଲେ କେତେ ମାସ ସେଇଟା
2011-2016 and released on
just a minute 2011-2016
arrested and released on bail my lord 24/6/2017
24/6
my lord
2017 ସେ ହେଲେ ଆପଣଙ୍କର ଏଇ ବର୍ଷ ହଉନି ସେ ଆପଣଙ୍କର ହଉଛି ହେଲେ ଗୋଟେ ବର୍ଷ 6-7 ମାସ ହଉଛି 7 months ହେଲେ 4 ବର୍ଷ 16 ମାସ ମାନେ 3 ବର୍ଷ 16 ମାସ ହେଲେ 4 ବର୍ଷ 4 ମାସ ରହୁଛି ହାଫ ପନିଶମେଣ୍ଟ ଯାଆନ୍ତୁ ତାପରେ ପେଣ୍ଡିଂ ଥାଉ ଏଟା ଲେଖିଦିଅନ୍ତୁ the land council for the state has ଏଟା ଗୋଟେ କୋଉ କେସରେ ରହିଯାଇଛି କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ ଦେଖିବ ତାକୁ land council for the state has produced the custody certificate eta which is taken on record land council for the petitioner 6 for an adjournment
may prefer interim bail my
नहीं interim bail ପାଇଁ ବି ଦରକାର half punishment ହୁଅନ୍ତୁ ଆଉ କିଛି ଅସୁବିଧା ନାହିଁ yes ଲୋକ କୋଉଠି ଆର
local man
ଆଚ୍ଛା ଠିକ
local man
yes next
my lord item number 14 my lord item number 14 my lord was pleased to give a direction on 14th November 2023 by order number 21 to produce the details of the sureties before this honorable court, but my client who belongs to district Mutihari of state Bihar could not procure a surety from Odisha, your honor. I have read a petition to allow this IA giving a bail either deposit by cash security or by surety from
ସେ ତ କ୍ୟାଶ ଦେଇଦେଇ ପଳେଇବେ ସେ ବହୁତ କେସରେ ହଉଛି ସେ କ୍ୟାଶ ସିକ୍ୟୁରିଟି ଦେଇଦେଇ ପଳେଇ ଯାଉଛନ୍ତି ଆଉ ଧରା ଛୁଆ ନାହିଁ
ମାନଙ୍କୁ ସେ ଦବ ସିକ୍ୟୁରିଟି ଦବ ଏଠୁ ପାଉନି ଆଉ 7 ବର୍ଷ already 7 years my lord completed
କ୍ୟାଶ ସିକ୍ୟୁରିଟି ଦେଇକି ପଞ୍ଜାବ ବିଜନେସ କରୁଛନ୍ତି ଆରାମ ସେ କ୍ୟାଶ ସିକ୍ୟୁରିଟି ଦେଇଦେଇ ପଳେଇ ଯାଉଛନ୍ତି ତାପରେ ଆଉ ଧରା ଛୁଆ ନାହିଁ
local security
yes
each local security from each place
then related file application accordingly what is the report that has come from
its address is correct permanent address is resident
Land and Council for the Mr. Diptis Patnaik Land and Council appearing to virtual High Court Parampur submits that the petitioner is unable to arrange this local surety. However, he submits that the petitioner is languishing in jail custody for more than 7 years, na?
More than 7 years, my lord. 2 months, 7 months.
More than 7. You both were arrested on the same day.
Same day.
But you are not released on bail and he has been released on bail.
I am not released on bail, my lord.
Submit that you take instruction if you are ready and willing to prepare the paper book, then file it so that early hearing can be. We want to obtain instruction whether the petitioner is ready and willing to prepare the paper books and file the same for.
Ready and willing. I am ready and
file it, take instruction, file the paper book and appropriate application so that because
paper book is ready in
I am taking.
Which one?
230.
Okay, so since cheta kati diyantu, since paper book has already been prepared, the matter be added to the hearing list in the week commencing from such and such date. February week include kar diyantu. Yes.
Public.
Item 15.
In this case, your lordship, custody certificate
IA किसी नहीं?
The regular bail application is pending because he was earlier granted.
What is the IA
bail.
that is pending according to you?
There is an IA for bail that is by 1084. 1084 of 2022. Earlier, he has been granted interim bail.
Provided that any interim application is pending, but the registry is not pointing out 1084.
Again, that is for regular bail. Earlier, he has been granted interim bail on.
Just a minute, just a minute. IA dispose of 1084. That was disposed of on 11/4/2023, and you are granted interim bail for a period of 2 months.
They have surrendered pursuant to that.
It's all right. Then you have to file another interim application.
File another IA. Lordship may fix up a date. He is an oral cancer patient. He has surrendered.
Mr. Panda, you have to file an interim application for bail.
I consider.
Mr. Panda, Sudipto Panda Land Council submits that he'll file an interim application for bail put up this matter as and when the interim application is filed.
I have also filed the surrender certificate.
That is there. ये जो बाकी गुड़ाक रहा ताकू ये दिन पूरे दो 16 तारीख दिन है because tomorrow is a hearing day, so it cannot be listed.
Item 43 is interim bail application.
16 तारीख.
बाकी रहा जो 16 तारीख
top of the list.
Tomorrow.
Tomorrow is a hearing day. So it cannot come. So
16 तारीख दिन top of the
16 तारीख दिन ये जो मैटर गुड़ा को कीजिए बाकी गुड़ा तोड़ कर